Director General of Police, ACP, requesting for investigate against that Upalappa, builder, revenue inspector, Tahsildar and Deputy Commissioner. On request of ACB, a Deputy Commissioner has granted a sanction in favor of village accountant by order dated 17/7/2020, Annexure H. On that basis of sanction, the police is also registered an FIR against that village accountant. The landowner Obalappa, MS Vishon Builders, and that village accountant has challenged the criminal proceeding initiated against them before this court. This court, in WP number 11408 of 2020, filed by the village accountant, has been allowed on 8 March 2021, quashed the criminal proceedings initiated against him. Now, by impugned order, the government has passed given a sanction under Section 17A of PC Act. Hence, he sought for stay of further proceedings pursuant to that Annexure M. In view of the above, there shall be an interim order. Stay of Annexure M dated. Stay of all further proceedings pursuant to Annexure M dated 31/1/2022 till next date of hearing. Government advocate is directed to take notice for respondent number 1, 2, 3.
P Manmohan.
Yes, 1 and 2. PN Manmohan is directed to take notice for respondent number 3. Learned counsel for the petitioner is directed to serve 2 sets of retribution copy and government advocate and 1 set on PN Manmohan.
Much obliged.
For order civil number 6, Sampath A for petitioner.
Yes. Yes. Where is your application? IA 1 of 2022 is filed for dispensation of production of cost title in judgment dated 27th February 2022, passed in WP number 51929 of 2014 and connected matter. For the reason stated in that application affidavit.
Application.
For the reason stated in the application, the IA 1 of 2022 is allowed production of cost title in respect of that judgment is dispensed. Yes, yellow case same. Yes, dispensed. Post this matter for admission next week. Yes.
Civil number 9, Shivakumar H for petitioner, AM Vijay, D Vachan, Prasad, PS Satish.
Yellow case dispensation. Yes.
Civil number 9, Shivakumar H.
Yes, Shivakumar. Memo filed by the advocate for respondent. Let's find this memo. Leave of the summer to return from the book due to non-payment of the yes. 3. AM Vijay, Learned Counsel, preparing for the respondent has filed a memo on 7/11/2020, taking leave of this court to retire from the case. The memo is taken on record. M. Vijay, Learned Counsel, is permitted to retire from the case.
Serial number 10, Udita Ramesh for petitioner.
Yes, madam. What is this, ma'am? We'll grant time. Yes, week's time is granted to comply the top.
Serial number 11, Prakash KM for
Lord,
petitioner.
appearing to the petitioner in this case, my lord,
Yes.
except the typed copy of the manuscripts, my lord, that's the representations, my lord, all other office objections we have complied, my lord.
The office objection.
Annexure K, adu typed
No other
copy.
alternative appeal to this matter, whether any petition filed on the same cause of action, synopsis to be ordered. Synopsis is not correct. All other you have complied with that.
ಸರಿ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ, ಎಲ್ಲಾನು ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ ಅದನ್ನ. Except serial number 7 ಸ್ವಾಮಿ. Typed
Yes.
manuscripts ಹಾಕ್ಬೇಕು ಅನ್ನೋದು ಬಿಟ್ಟು ಬೇರೆ ಎಲ್ಲ ಮಾಡಿದೀವಿ.
Yes, what is this matter, Mr.?
My lord, the matter is, my lord, the respondent BDA, my lord, acquired the land for the acquisition of for the formation of peripheral ring road in the year 2005. Wide preliminary notification dated 12/12/05, my lord, and
Yes.
preliminary notification for the formation of Kempegoda layout, my lord, on 21/5/08, and
Yes.
final notification on 18/2/2008, 10, my lord.
Yes.
And my lord, the petitioners are the landowners of the land bearing survey number 45 to an extent of 9 guntas, my lord.
Yes.
The originally one Galapa is the owner of the land, my lord, measuring to
Yes.
an extent of 2 acre 20 guntas, my lord. Out
Yes.
of that 2 acre 20 guntas, my lord, 1 acre 33 guntas was acquired for the formation of peripheral ring road by the respondent, my lord. The remaining 27 guntas was acquired for the formation of Kempegoda layout. The
Yes.
petitioners have made a representation from the inception, that is from 2008, my lord. The respondents have not considered. They are residing there. They are residing within the village, my lord. The scheduled property is scheduled property is situated within the vicinity of the village, and the adjacent lands are not acquired, my lord. These petitioners are residing and forefathers are residing from past 150 years in the said village, my lord. And they are belongs to a weaker section and they are illiterates. And in spite of the representation furnished, my lord, the BDA has not considered, my lord. And the moreover, my lord, now the BDA is acquiring this 29 guntas to give the compensation to the land for which they have acquired in the own same survey number, my lord. 1 acre 33 ಗುಂಟಾಸ್ಗೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ಲಿಕ್ಕೆ ಈ ನನ್ನ 27 ಗುಂಟೆಲಿ ಏನು ನಮ್ಮ ಶೇರ್ 9 ಗುಂಟಾಸ್ ಇದೆ ಅದನ್ನ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡು ಅದರಲ್ಲೇ ನಮಗೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬಂದಿದ್ದಾರೆ ಸ್ವಾಮಿ. We are residing there, our houses are there, hence I request my lordships to stay the.
No, Mr. When that acquisition notification has been issued?
My lord, acquisition notification, preliminary notification was issued for the peripheral ring road in the year 2005, my lord, and for the Kempegoda layout wide annexure A, my lord, on 21/5/2008.
Yes.
And final notification on 18/2/2010, my lord.
Then after 12 years, you are challenging and seeking for an stay.
No, my lord. The problem is, my lord, they are illiterates and they have given many representations, my lord. I have placed before my lordship the representation furnished.
No, that will not make any distinct, Mr. Giving a representation.
You
are challenging the acquisition.
ಅಲ್ಲಿ ಹೋಗಿರೋ ಇಂಜಿನಿಯರ್ಸ್ ಇಟ್ ಇಸ್ ಸಿಚುಯೇಟೆಡ್ ವಿತ್ ಇನ್ ದಿ ವಿಲೇಜ್. ಹಳ್ಳಿ ಒಳಗಡೆ ಇರುವಂತ ಜಾಗ ಇಲ್ಲ, ನಾವು ನಿಮಗೆ ತೊಂದರೆ ಕೊಡೋದಿಲ್ಲ, ಬಿಟ್ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಫೈನಲಿ ನಾವು ದೇ ಆರ್ ಟ್ರೈಂಗ್ ಟು ಫಾರ್ಮ್ ದಿ ಲೇಔಟ್ ವಿಲೇಜ್ ಒಳಗಡೆ. ಆಲ್ ಅದರ್ ಅಡ್ಜಸೆಂಟ್ ಮನೆಗಳೆಲ್ಲ ಬಿಟ್ಟಿದ್ದಾರೆ.
No, you take notice, that's all. Yes, issue notice.
Status quo, my lord, ಅಲ್ಲಿ ಇನ್ನೂ ಏನು ಆಗಿಲ್ಲ.
We don't know what is the stage after 12 years, whether that land is available or not.
There, my lord, there we are in possession. I have placed the photographs, my lord.
Yes, if you are in the position, be happy there. Yes.
ಅದಕ್ಕೆ ಸ್ಟೇಟಸ್ ಕೋ ಸ್ವಾಮಿ ಇನ್ನೇನಿಲ್ಲ. We are in possession. ಅದಕ್ಕೆ ತೊಂದರೆ ಕೊಡೋದು ಬೇಡ ಅಂತ ಸ್ಟೇಟಸ್ ಕೋ at least. That's my request, my lord.
No, this is a case has to be dismissed on threshold on delay and latches.
No, my lord, we are given representations from 2008 is Annexure K, my lord.
Issue notice.
Annexure K, page number 54.
Government advocate is directed to take notice for respondent number 1. Yes, BDA. Where is the BDA?
Appearing for the BDA, my lord.
Yes. NR Girish is directed to take notice for respondent number 2 and 3. Learned counsel for the petitioner is directed to serve one set of petition copy on government advocate and 2 sets on Sole circumcision. Yes.
One request, one submission. So,
Yes.
the observation is if the petitioners are in possession, not to disturb that.
No, Mr. No, that cannot be, sir. After 22 years.
My lord.
No, Mr.
To that
Prakash,
extent-
there is so many judgment of the Supreme Court that acquisition cannot be challenged after long time. It is a 12 years
My lord, that's
notification now you are challenging. Yes. It has to be dismissed on the ground of delay itself. Mr. Yes.
Number 12, Kumuda TA for petitioner.
I appear for the petitioners, my lord.
Yes.
The office objections have been complied.
Yes. What is this, Mr. What is this case, madam?
This is a matter for setting
In the
aside the
meantime,
order dated
Petitioner is
23/2000.
directed to comply the tax. Yes, madam. What is this, Mr. No, I have just served the copy. Can be disposed of. The passing of general award. Yes.
Yes, my lords.
Yes, we will dispose of, madam.
Much
Okay, yeah.
obliged, my lord.
Yes. TV Chandrasekhar is directed to take notice for respondent number 2 and 3. Government advocate is directed to take notice for respondent number 1. Dispose of. Yes.
Serial number 30, Nagaraja D for petitioner, K.R. Srinivas.
Yes. Why pass over, mister? Where is your colleague? Pass over. Yes, Mr. Krishna, pass over.
14, S.V. Prakash.
Appear for petitioner, my lordship. Kindly weeks time granted, my lordship.
2 weeks time is granted to comply the top subjection.
Much
Serial number 15, Mahesh Arupati for petitioner.
Yes, Mr. Mahesh. What is the top subjection? Huh? Yes. Now that who is appearing? No, you are appearing for respondent. Muda. This petition is filed by this thing. Bipin. Yes. Yes, Bipin. He has enclosed that presentation. It's of your office. Therefore, I am asking. Is there his office, mister? When you are filing, you should be very careful. Our office notice. That's what I am seeing. H. Shivram's name is there. Then he's saying he is appearing for the response. Yes. Yes. Yes, Mr. Bipin, what is Mahesh? Yes. 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 On the ground of their yes, he must not implement the absolutely identical issues, declare that lapsed insofar as the petitioner is concerned. They are abandoned that acquisition. Yes, Mr. Shiram. In terms of that, we will dispose of. Yes. Government advocate is directed to take notice for respondent number 1. It is Shivram. He is directed to take notice for respondent number 2 and 3. Same notification. Yes. The preliminary notification dated 10/7/2092 and the final notification dated 19/3/1996 were issued for acquiring the land for the formation of Bugadi third stage extension. The said notification includes the petitioner's plans measuring land bearing survey number 17/1, measuring 2 acres 34 guntas. In Bugadi village. Huh? Yes. Now, what is that extent which has been acquired in your distinct, sir? Ether acquisition, where issued land formation of zone. The said notification includes the petitioner's land measuring 14 guntas. Yes, 14 guntas in survey number 17/1, situated in Bugadi village, Mysore Taluk, Mysore district, bounded on scheduled boundary. Yes. It is not disputed that the award was not passed, the position of the land was not taken, and the scheme was not implemented. In an absolutely identical case, this court, by its order dated 9/7/2015, in WP number 25089 of 2015, has issued a declaration that schemes could lapse insofar as the petitioner is concerned. Petitioner in WP number 25089/2015 is concerned. Next paragraph. As the facts of this case and the facts of the WP number 25089 of 2015 are identical, I dispose of this petition in terms of the said order, declaring that scheme for the formation of Bugadi village and the acquisition proceedings therefore have lapsed insofar as they pertains to the petitioner's scheduled land is concerned. Yes.
Number 16, Janardhan J for petitioner.
Yes. Yes. What is that, Mr. Victor? Oh, you have not paginated the petition itself. Yes. 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 Where is that undertaking? Yes. 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 Now that in spite of that order, that then you have not filed any contempt. Where is that undertaking? Yes. ಹಂಚಿಕೆ ಮಾಡಲು ತಮ್ಮ ಪ್ರಾಧಿಕಾರ ಫೋನ್. Yes. 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 They have not done it. Have you approached that authority by filing in a representation? Yes. Issue notice. Government advocate is directed to take notice. Yes, BDA. Anybody is there, BDA?
Yes, my lord.
Yes.
Appearing for the BDA, my lord.
Yes, who is that?
GM Chandrasekhar, my lord.
Yes,
Yes, ma'am.
yes,
GM
you are there. You have taken that notice in the earlier. Yes. Government advocate is directed to take notice for respondent number 1. Who is that? GM?
GM Chandrasekhar, my lord.
GM Chandrasekhar is directed to take notice for respondent number 2. Whether counsel for the petitioner is directed to serve one set of petition copy on government advocate, one set on GM Chandrasekhar. In the meantime, the net counsel for the petitioner is directed to comply the top subject.
Serial number 17, Rahul Shettikar for petitioner.
My lord, apparent
Yes.
petition in this case, my lord. My lord, sir, the office objection is that serving of the copy to the KIADB, my lord. My lord, I'll serve the.
Yes, what is this, Mr.?
My lord, I will serve the copies on the.
TM
Venkat Reddy, my
Venkatreddy
lord.
takes notice,
I'll serve the copies.
KDB.
Now that copy you have to serve in advance.
Yes, my lords. I was unable to.
Then only you can
Copies.
maintain the writ petition.
My lords, I'll serve copies now. I'll serve the
Next
copies.
week.
Yes, my lords.
Next week. Let them serve the copy. Yes.
TM Venkatreddy take notice for it.
No, he wants to comply that within 1 week. Let us see. Yes, whom he will serve, who the KDB will give, then yes. Yes, week's time is granted to comply the top subject.
Janardhan G for petitioner.
Yes. What is this, Mr.? Yes. 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 Okay, ಇಲಾಖೆಯ ಸೂಕ್ತ ಆಡಳಿತ ನಿರ್ಣಯ ಕೈಗೊಂಡು ಎಂದು ಕಾನೂನು ಇಲಾಖೆ ಅಭಿಪ್ರಾಯಪಟ್ಟಿದೆ. Yes. 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 Now, what is that decision now that taken? Yes. Issue notice. Government advocate is directed to take notice. Yes, BDA. Gopal. Yes.
Yes, my lord. BDA, my lord. GM Chandrasekhar.
Yes. Gopal is directed to take notice for respondent number 2. Learned counsel for the petitioner is directed to serve one set of copies on government advocate, one set on Gopal. We give it to the juniors. Let them all. These are all that not complicated matter. Therefore, I am just giving that.
Yes, ma'am.
Yes, in the meantime, petitioner is directed to comply the top subjection.
Number 19, Vasant Kumar HP for petitioner.
Yes. What is the top subjection? All that you are not, nobody is complying the top, huh? Yeah, why age proof is not mentioned? Yes, what is this, Mr.? Yes. Yes. Why? No, yes. Yes.
The same was cancelled. This fact is brought the notice of the BVA. Then BVA has decided to allot the audit side.
Yes.
Another day the decision taken in the BVA to allot the audit side.
Yes.
Even after the issue, they taken the decision by the BVA.
Yes.
Even not allotting the audit side, the cancellation order came to be issued.
Next
So, challenge before this court has actually cancellation on that.
Yes.
And direct the BVA for allotting the side.
Yes.
So after giving the direction, no action has been taken.
Yes.
Hence, contempt came to be filed.
Yes.
With the pendants of the contempt, these subject say that doesn't get to be issued saying that it's not paid balance.
Yes. What is that second round of litigation?
Not paid balance. That is only endorsement says.
That has been again passed. Yes.
It was passed by the Supreme Court and directed the BVA to consider upon the patient of allotment of audit side.
Yes.
When they are not taking such a direction, then the contempt came to be filed. When we initiate the contempt proceedings for avoiding contempt proceedings, again the adjustment came to be issued saying that they are not paid the balance.
Yes. Now the same order has been passed.
Yes.
Yes, who has appeared in the earlier G. Lakshmi Shrav. Issue notice. Government G. Lakshmi Shrav is directed to take notice for respondent. Learned counsel for the petitioner is directed to serve one set of copies on G. Lakshmi Shrav. In the meantime, petitioner is directed to comply the top subject.
Number 20, Krishna Reddy R for petitioner.
Appear for the petitioner in this case, ಅದರಲ್ಲಿ SN Bhatt advocate ಆಗಬೇಕು ಸ್ವಾಮಿ. ಅದ್ರಲ್ಲಿ ಕೃಷ್ಣ ರೆಡ್ಡಿ ಅಂತ ಅವ್ರ ಹೆಸರು ತೋರಿಸ್ತಾ ಇದೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿರೋದು SN Bhatt.
Yeah, why that Krishna Reddy name has come? What of sir? SN Bhatt file ಮಾಡಿದ್ರೆ Krishna Reddy ಅಂತ how does office can do that? Office is directed to show the name of SN Bhatt who is appearing for the petitioner. Then Krishna Reddy ಯಾರಾದ್ರೂ ವಕಾಲತ್ ಹಾಕಿದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ?
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಸ್ವಾಮಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಸ್ವಾಮಿ ಅದು.
Yes, in place of Krishna Reddy or Krishna Reddy for petitioner. Yes. Release this
mandamus issue notice ಆಗಬಾರ್ದು ಸ್ವಾಮಿ. ಅದು only consider the representations.
Office objection ಏನಪ್ಪ?
Office objection small corrections ಇದೆ ಸ್ವಾಮಿ. ಅದು ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
No, court fee is not paid.
ಇಲ್ಲ ಮೇಡಮ್, already paid madam. Day before yesterday I paid madam.
Then why the office is showing all this complied office objection?
ಸರ್ ರೆಸಿಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಸರ್ ಆಫೀಸ್ಗೆ?
ಆಫೀಸ್ಗೆ ರೆಸಿಟ್ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಅದು
you have to pay the court fee, Mr. First only then yes.
Day before yesterday already paid madam.
Court fee receipt ಎಲ್ಲಿದೆ?
ನನ್ನ ಹತ್ರನೇ ಇದೆ ಸ್ವಾಮಿ. ನಾನು
then you have to place before that office Tuesday. Yes.
Tuesday sir.
Yes.
21, Ajit PD for petitioner.
In the meantime, petitioner is directed to comply the top. Yes. Yes. Date of? That is the only office objection. Have you paid the court fee? Yes. 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 What is that matter? Yes. Yes. Have you approached that BTA by giving an, no, it is 2006. What are you doing all this day? Yes, you are there, Mr. BTA. Seriously. BTA, you are there. And who is there for BTA? Any other councils? Youngsters? Gopal Bilmani. Yes, Gopal Bilmani is directed to take notice for respondent number 1. Learned counsel for the petitioner is directed to serve one set of copies on Gopal Bilmani. In the meantime, petitioner is directed to comply the top subjects. Yes, you serve copy to that counsel.
Shivakumar N for petitioner.
My lords, I am representing the petition in this matter, my lords.
Yes.
This is the matter. We are challenging the accusation notification, my lord. My lords, the accusation notification has been received preliminary notification on 1988.
What is that office objection, Mr.?
Office objection, my lord, legible copy, annexure A and B produced by the
Court fee has paid.
Court fees, 100 rupees I have paid, my lord. On 5th.
Where is that?
5/2/2022, I have paid. Through online, I have paid, my lord.
Where is that acknowledgement?
Acknowledgement, I have not filed, my lord.
You furnish that acknowledgement. Only after paying the court fee, you can entertain.
My lord, I have paid, but only one submission, my lord.
Yes,
in the similar writ petitions, your lordships only state the notifications, my lord.
No, Mr. Unless court fee has been paid, writ petition cannot be entertained.
Yes, but I paid. I will produce the acknowledgement, my lord. Please.
Produce acknowledgement, then I will have it on Tuesday. Yes.
Week's time, date may kindly be fixed, my lord.
Tuesday.
Please, my lord. Grateful.
If you want
grateful.
Longer date, I will give it, Mr.
No, my lord. No, my lord. Grateful.
Yes. Yes, that is the only objection. For what mandamus you have sought, Mr. Why? Yes. Yes.
After reaching the BD has allotted this site in favor of others now, and she has voluntarily demolished the structure and handed it to the BDM now.
Yes.
And thereafter she issued the application for seeking the objective site. There is no special considered by the respondent. And after filing the application, the land
Okay.
order
Yes.
for providing the objective site
Annexure? Yep. Yes. Yes. What is this order? Read.
The initiate holder prior to initiate acquisition, there is a possession by the sale. They are entitled to the in the view of the matter of the reported judgment INR 2005 36 committee is given over VA.
Yes.
According to that, they are passing order to provide the application.
Yes.
They have not given the application, hence I will represent.
No, from 2010, order has been passed.
This was subsequently I filed the petition.
No, 2010. What is that order? You read that. ಪರಿಶೀಲಿಸಲಾಗಿ ಬದಲಿ ನಿವೇಶನ ಹಂಚಿಕೆ ಅರ್ಜಿದಾರ ಅರ್ಹರಾಗಿರ್ತಾರೆ.
ವಿಸ್ತೀರ್ಣ 2 ಗುಂಟೆ ಪೈಕಿ ಅರ್ಜಿದಾರರು ಕಲಿಕೆ ಪಡೆದಿರುವ 30.40 ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಲಾಗುತ್ತದೆ. ಅರ್ಜಿದಾರರ ಕಂದಾಯ ನಿವೇಶನ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಒಪ್ಪಿಸಿಕೊಳ್ಳಲಾಗಿದೆ ಎನ್ನುವ ಬಗ್ಗೆ ಪರಿಶೀಲನೆಗೆ ಅಧಿಕಾರದ ನಿವೇಶನ ಹಂಚಿಕೆ ನಿಯಮಾವಳಿ 8 ಮೂಲಕ ಮೂಲ ದಾಖಲೆ ಪರಿಶೀಲಿಸುವ ಹೊರತುಪಡಿಸಿ 30.40 ಅಳತೆ ಬದಲಿ ನಿವೇಶನ ಹಂಚಿಕೆ ಅರ್ಜಿದಾರರು ಅರ್ಹರಾಗಿರುತ್ತಾರೆ. ಈ ಆದೇಶವು
No, that's what. From 2010, what are you doing? No, they have not allowed. They will not allot, Mr. What you are doing there?
Subsequently, the new authority come to the petitioner's property is trying to dispose of the petition to the agriculture. And immediately support the BDA. Voluntarily, surrender the site to the BDA and see herself was demonstrated by the petition.
Yeah.
They served in the presentation on 5/2022.
Yes, issue notice. There is the No, he has taken notice. Mr. You take notice. Also is directed to take notice for respondent 1 and 2. Learned counsel for the petitioner is directed to serve 2 sets of copies on. Yes.
Shivakumar N for petitioner.
My lords, I am representing petitioner. It's similar to serial number 22, my lords. It may have done Tuesday, my lord. I will produce the.
Tuesday. Yes,
Please.
yes.
And 25 also, my.
25 Tuesday. Yes.
Please.
Ajit Kalyan for petitioner. Serial number 26, Ajit Kalyan.
Yes, Ajit Kalyan. 2 weeks time is granted to comply the top subject.
Number 27, Manjunath.
I'll have to serve the copy on the advocate for KIDB. I will serve the copy.
Which one, Mr.?
27, my lord.
Number 27, Manjunath BS.
Yeah, my lord, I appear for the petitioner. I'll have to serve the copy on the advocate.
Appearing for petitioner in this matter, my lord. My lord, serial number. My lord, serial number 26, my lord. I may be permitted to make a submission, my lord.
No, madam, you have to use that proper instrument. I can't hear your voice. Yes.
My lord, am I audible now, my lord?
Yes.
This petition is filed for a writ of mandamus to consider representation, my lord.
Voice
In
is
this
not
matter,
clear, madam.
the only office.
Yes, Tuesday. By the time you clear the top subject. Yes, Tuesday. Yes, Mr. 26, 1 week's time is granted to comply the top subjects. 26 hours. 27. Yes, Manjunath.
No, my lord, I have to serve the copy on the advocate. That is the objection for KDB to be served.
Yes,
I will serve the copy, my lord.
When do you want? Next week?
My lord, week's time, my lord.
Yes, week's time is comply the top subject.
Number 28, Fayaz BG for petitioner.
Yes.
28.
Yes, Fayaz week's time is granted to comply the top subject.
Number 29, Roshan HC for petitioner.
Roshan HC. 2 weeks time is granted to comply the top subject.
Number 30, Shivashankar K for petitioner. Manivannan.
My lord, I appear for the petitioner.
Yes.
My lord, in this matter, Lordship, the trial court has released the compensation during the pendency of the suit.
How many matters are there, Mr.
Lord, only one, the last one, another one matter is there. Lord, and Lordship has already granted all the matters. Lordship has granted the interim order.
Different parties, they are all
Same parties, my lord, they're all same parties.
Wait, Shivkumar. Wait. Yes. No, see that Manivannan is appearing for in all cases. He in his client's favor that there is a releasing of the amount. Others are family members.
Yes, my lord, all are family.
All that each family members has filing different writ petition. No, now that each family members has entrusting different councils and filing that they are. But they're seeking for a stay of same order.
Same.
Yes. Special Land Acquisition Officer, DK? Srinath. Yes, he is directed to take notice for respondent number 1. 2 Garo.
But notice has to.
Wait, Mr. 2 and 5. Manivannan is yes. Aviator is undertaken to appear for 2 and 5. New Yarge or 4. PV Chandrasekhar is undertaken to appear for respondent number 4. Allige 5 varige 6, 7, 8, 9 issue emergent notice. What is that interim order you have granted in that case?
Sought for stay of the order passed by the Right, Annexure B.
Wait, Mr. Shivkumar. Wait, Mr.
Please.
Yes. Interim order, yes, sir. The stay of order passed by 8th additional district and session judge Bangalore, rural district of Bangalore, in miscellaneous number 117 of 20 on IA2 dated 10/1/2020 till next date of hearing. Yes. Call this matter along with the. Yes, all along with the.
Number 31.
Lord, I beg to appear for the petitioner's counsel in this matter.
Yes.
My Lord, the office objections are three office objections are there. They are formal in nature. In view of the urgency, may I seek my Lord's indulgence for taking up the matter. The
What
question
is that office objection, Mr.
Legible copy to be produced and the certified copy of Annexure K to be produced. And those objections will definitely comply, my Lord, in a day or two. And the urgency of the matter is that a landowner said the petitioner is a purchaser of a revenue site way back in the year 1999 itself. And my Lord will get the sale deed at Annexure B. And I purchased a particular site, and the land, when this became the subject matter of acquisition, the BDA proceeds with the acquisition, and I did not resist the acquisition. BDA layout gets formed. What does the landowner, the persons who claim under the landowner do is to go to BDA and obtain a consent award in respect of the very property at page number 44. And I am deprived of the ownership of the site because the BDA has a scheme of giving me an alternative site, provided I show to be the owner and my possession from me. Yes, ma'am.
The acquisition has been, notification has been issued in whose name?
The notified Khatedas, my Lord. What happens is the difficulty is that I will demonstrate at page number 44. The BDA recognizes the existence of the revenue sites. May I just draw my Lord's kind attention to page number 48, my Lord. Not that I am a stranger to the property.
Have you filed an objection?
Yes, my Lord. 2009. Kindly see the annexure. I have filed the objections way back in 2009, which is at Annexure G, and they disregard my objections. And now proceed and form a layout. They allot 14,000 square feet of land to this landowners, persons claiming under the landowner. I will be left in the street, my Lord. And if they proceed, and the BDO is going to say that, look, we are not taken possession from you, and you are not entitled for alternative site. And the factum of that is acknowledged at page number 48.
Now that what is the stage now?
The stage is they are proceeding with allotment of alternative site as per the consent award, which my Lord gets it at page number 48 in respect in favor of respondent number 6 to 8. 14,376, which amounts to 1340 sites the landowners get by suppressing the factum of selling around 74 sites in the survey number. And I am one of the one of the purchasers by a valid sale deed. BDA has not come back. 2009, I have filed my objections, followed by repeat representations.
Yes.
May I submit, my Lord? Therefore, the interim prayer, if they are allowed, if BDA is allowed to proceed with allotment of alternative, the allotment of sites as per the proposal at page number 48, as per the award, in favor of respondent number 6 to 8, I am a poor 30-40 site purchaser in the very same number which the BDA acknowledges. May I read that relevant portion?
Ultimately, this land has been, this site has been granted to your vendor. Then you will substitute it to your vendor.
No, it will not. It will not. My vendor will sell it away. It is not the lease come sale deed. My vendor has suppressed the factum of having formed the layout. My persons who are claiming under my vendor have suppressed the factum of having formed a layout and having sold the site to me. I will not get anything, my Lord. Therefore, there is an urgency.
No, that sixth respondent has formed the site.
The persons who have sixth respondent, these 6 to 8 respondents are claiming under one Surya Narayana Rao who formed the site, and they claim under Surya Narayana Rao.
Surya Narayana Rao is the family member.
Yes, yes, definitely, man. Definitely, definitely. There is no third party.
You are appearing? Petitioner.
My colleague is there. My colleague is there just in
Yes.
order to facilitate.
V.V. Shankar Narayan Rao, learned senior counsel appearing for petitioner, has submitted that third respondent number 6, 7, 8 are the landowners of the property. They have found the revenue site and sold the site in favor of petitioner. Petitioner has purchased the same by registered sale deed as per Annexure A. The said land has been
Annexure
acquired.
B, my lord. Annexure B.
Annexure B. Annexure?
B, my lord.
Annexure B. Said land later has been acquired by the BDA. Under the government order, the land loser is entitled for alternative site. The vendor of the petitioner suppressing the fact that the property has been sold in favor of the petitioner has approached the BDA for allotment of alternative sites.
Sites in lieu of compensation. It is not alternative site.
Approaching the BDA for allotment of a site alternative to that compensation. Now that they have passed an order.
The order is at 18/12/2018. Annexure K is the consent award.
Yes. Pursuant to that consent award, the BDA is making effort to allot the land in favor of respondent number site in favor of respondent number 6, 7, and 8. Hence, he sought for interim order. In view of the above, there should be an interim order. Say the operation and implementation of the consent award dated 18/12/2000. Say all further proceedings pursuant to the consent award dated 18/12/2018 passed in LAC number 1128 of 2009 and 10 produced as Annexure K till next date of hearing. K. Krishna is directed to take notice for respondent number 2, 3, 4, and 5. Government advocate is directed to take notice for respondent number 1. Issue emergent notice to respondent number 6, 7, and 8. Then a counsel for the petitioner is directed to serve one set of petition copy on government advocate. 2 sets on K. Krishna.
I'm greatly obliged, my lord.
Yes.
Then interlocutory application matter, serial number 32. Samant Nayak for
No,
petitioner,
the 32, I am hearing for the counsel for petitioner.
Yes.
Referring for the respondent.
Petition is filed not seeking a declaration that the acquisition in respect of the petitioner's land,
yes,
which is number 81, measuring about 1 acre, 35 gundas plot, has lapsed under
yes,
section 20 PDA Act.
Yes.
Now, this acquisition was done for BTM 6th phase.
Yes.
Not I produced documents of the learned single judge of the Honorable Court.
Yes.
Holding that these acquisitions have lapsed because it is not substantially implemented.
Yes.
One judgment where the statistics are provided. If the Lordship will kindly turn to page 110.
Yes. Yes.
Lordship has page 110.
Yes.
Not 6, para 6.
Yes.
In the above facts and circumstances, it is to be noticed that there is no substantial development of the layout. This is exactly the same as claimed by the respondents. In that, out of the extent of land measuring 388 acres, 98 guntas of Pulimau village, and the extent of land measuring 174.25 guntas of Varakere village, the admitted development is only to the extent of 31 acres, 2 guntas in respect of Pulimau village, and 7 acres, 20 guntas in respect of Varakere village. Therefore, the contention that the scheme has been substantially implemented is not tenable.
Yes.
Now, this judgment, Lord, out of the 5 judgments, apart from one case which is before the division bench, this judgment has become final. They have not has not carried it before the division bench.
Yes.
Therefore, Lord, I am not sticking to my case that this my land also, which is part of the same acquisition, Lord, there is no implementation. Lord, my learned friend, my advocate on record is having a memo along with some photographs.
Yes.
Lordship, not kindly have a look at that, not the entire village actually.
This is also the scheme development of Hulimau village.
Yes, Lord, BTM 63.
Yes.
Okay. This is Arikere village. 2 villages they have acquired.
Yes.
Hulimau, my land, Lord, is in Arikere village.
No, in respect of that Arikere village also, this court held that scheme is lapsed.
Yes, Lord, not substantially implemented and lapsed. Kindly see that. May I read it again?
No. That's what I make out that it is a reference to that Arikere village also.
Also, yes.
Yes.
Lord, that photograph, Your Lordship will see, Lord, it's of Arikere village.
Now, which is that number?
Lord, survey number 81 is my land.
81. Yes.
Which is right in the middle, Lord, Your Lordship land.
Yes. Yes.
So this is built up with small houses, and we are continuing to be in possession. All around it, all the survey numbers around this land is fully built up, and none of these lands, Lord, are part of the acquisition anymore. Either they have been denotified or they have been quashed not by this honorable court.
Yes.
And these are all now revenue pockets with built up houses, people residing.
Yes.
Therefore, squarely, Lord, provisions of section 26 of the BDA Act will apply.
Yes.
And I am for a declaration.
Yes, Mr. Chandrasekhar.
Yes, Mara. That what my learned senior counsel has stated, it depends each land to land survey number and everything, Mara. And your Lordship may kindly note that preliminary acquisition was in the year 1987. And the final notification was in the year 1990.
Yes.
And the petition filed in the year 2018.
Yes.
And for the first time, they pressed for the interim prayer by this honorable court. But no interim order was granted by this honorable court rightly.
Yes.
And my lord, now at this stage, no such subsequent developments, no further developments have been taken by this respondent. At this juncture, it is unfair for the petitioner to seek for interim prayer. On the other hand,
No, not interim prayer. Mr. Chandrasekhar. Now we are hearing that. If you are ready, I am hearing that.
I was under the impression.
There is no question of delay in lapsing.
Yes.
We are approaching that because you have not developed that land for long years. So many years you have not developed.
Yes. Rashme, if it is for disposal, I will getting the certain documents which I wanted to rely upon. And it may be disposed of at the next stage itself, my lord. I mean, next date of hearing or
now that the issue is very narrow.
Yes.
That whether you have implemented the scheme or not, in respect of that very notification, this court is already held.
Yes.
You have not implemented the scheme.
Yes.
How do you get over from that? You have to answer.
Yes, Marad. That is and if it is so, Marad, I will make put before your lordship for certain documents as to acquisition of the land, taking over the possession and deposition of the award amount, all the necessary documents.
No. Under 27, that is not the criteria. Yes. 27 is that how much, whether you have substantially developed that property. This court is already taken a view.
Yes.
You have not developed.
But it is in some other survey numbers, not in this survey.
No,
anyway, I will.
This is for the scheme.
Yes, madam.
It is not for, you can't take by survey number wise. You have to take it by the
entire scheme, madam.
Yes, when do you want?
So I will get the instructions from my organization and make a submission.
Why it is posted today?
Hearing
on IA, madam.
Has been posted.
What is that IA, Mr. Prana?
Yeah.
IA I have filed for interim prayer. I am not pressing, Lord. Your Lordship may keep the IA alive.
Yes.
Last date also, Lord, the time was sought by the BDA.
Yeah, because of this stage only, madam.
Therefore,
now that Chandrasekhar, you have to file an objection
Yes, ma'am.
Placing the material before this court,
Certainly.
whether substantially you have implemented the scheme,
Certainly.
then how you will get over from that earlier order passed by this court?
That is the
Yes,
crux,
21.
madam.
Yes, 21.
Around 20 days, madam.
I'm sorry, Lord, this is not fair. It is 2018 matter.
Yes, yes. It is 90 acquisition. 90 acquisition.
Yes,
madam.
we'll
Yes,
have
sir.
it on 24th.
24th.
Yes, 2 weeks.
Please.
Not any
Agಬೋದು.
early.
24th ಆಗ್ಬೋದು sir.
4 years now, Lord, this petition is pending on this small issue.
24th, otherwise 22nd.
24th is okay, ma'am.
Yes, 24th. Yes.
Please.
At the request of counsel for respondent number 2 and 3 as a last chance, release this matter on 24th. Yes.
Ablash.
Grateful.
Yes.
Serial number 33, ETC B for petitioner, C.S. Shivananda.
Yes.
But sir, petitioner had earlier approached this honorable court,
Yes.
challenging the action of the Indian Institute of Science.
Yes.
It's not Lord appointing her as a principal research scientist. She has a PhD with 30 years experience. They kept her in a technical administrative cadre. This honorable court found Lord that she was eligible for transfer to the scientific cadre. Found Lord that the IISc had duplicated records and backdated them. Should have in fact granted the relief, but however, in light of the observations, directed them to consider and pass a speaking order. Now, by the impugned order, what they have done is Lord, some vindictive attitude. They have demoted her. She was technical cadre grade 3.
Yes.
Instead of making her a principal research scientist, which they have done to others with PhDs, they make her a scientific officer grade 1.
Yes.
And demote her. That is the order challenge. Now, while hearing Lord, this honorable court made an order dated 9/1/2020
Yes.
that no coercive steps should be taken for any recovery against her.
Yes.
Because they wanted to take that action also. They have vacated her from her accommodation.
Yes.
P6/2021, they filed their counter. We have filed refund. The matter of words is ready for disposal.
Yes.
Now on 12/1/2022, they make an IA for vacating.
Yes.
And they want your lordships to hear that.
Now that what is that interim order has passed? Where is the
It's order dated 9/1/2020.
9/1?
Respondents shall not initiate any coercive recovery proceedings against the petitioner.
Yes.
So what do they want to recover from you? Let them assist your lordships and the main matter can be heard.
What is that interim order you want to attend? Yes. Yes.
I accepted that. In January 2021, application is filed for earlier. A statement is made that since 2018 till today, salary is not being paid.
Yes.
If I may just request you to kindly take note one, I'll just read out a few lines. Page 129 of the main petition. What happened, Lord, is there are two cadres. One is technical officer and one is scientific officer. For technical officer, the age of retirement is 60. Petitioner will not admittedly as the date of her retirement was in the technical day, and she retired in the year 2018. Based on the order of this one, the case was to be considered for the period of scientific officer, then the age of retirement will automatically extend. That was extended by virtue of this improved order, which is improved to the her date of retirement was not extended up to 2052. What happened was that immediately they requested also to candidate page 129.
Yes.
But from the middle, considering the above institute passes the following order. In that, my lord, clause number 4.
Yes.
We can rather continue the scientific officer till grade 1 is acquiring higher qualification PhD on 7/8/2009. She will be evaluated by a committee for possible promotion to scientific officer with effect from 7/8/2009. And if based on her being successful evaluation to her scientific officer, her placement in P-Band 4 will be decided. All further evaluation will be subject to outcome of her evaluation to the post of scientific officer. Next clause. KT Ranganathan will retire from service on superannuation on 31/7/2023. Now, clause 6 is subject to clause 4 and 5. She has to, after passing of this order, appear before the evaluation committee. And based on her evaluation, further course of action will be decided. Now, she immediately after this order, she approaches this one because her retired benefits were paid. We have accepted the order and not taken any further step. Now, my lord, since this order, she has never reported for duty. Admittedly, there is no interim order not to report for duty or permit her to not do for duty. In 2022, she makes an application saying that I have not been paid salary. Immediately,
I have not sought for salary, my
application.
friend. I'm sorry. I have not sought for
The statement
salary.
is
I have responded to them saying there is no question of my reporting and you have not paid me any salary. I am not making that grievance. Now, Lord, if my friend, one second, if my friend has accepted the interim order, question of vacating doesn't arise. Beyond that, Lord, I will submit the merits.
No, that's what. That I will make it. That let him complete.
His
Yes.
statement in the application, statement is made. It is saying that the salary since 2018 is now, my Lord, I make an application for vacating the interim order. In the statement of objections to my application, the statement is made that we not retire and dues that I had paid to her in the year 2018 are adjusted towards her salary dues. But admittedly, she is not reported for work. Let her file an affidavit whether she is come to work after passing of that. There is no interim order for her to stay away from.
No question of adjusting and all will not arise just because direction is no. Let them make any statement. It will not. It will not. See, now you can't make any effort to recover because interim order. They may make 100 allegations saying that this can be adjusted and all. That can be done only after the final order has been passed. Nobody can.
That is the reason I have kept quiet for 2 years and ready for this.
Yes, we'll fix the date. Yes, that's what. Now that question of vacating the interim order. Both. No, just because he is making some this thing in that observation in that application, it is. It will not make you that final order has been passed the court. Yes, that will not be. Yes. Yes, Mr. Senior Counsel.
16th, Lord, I will prepare a synopsis.
Yes.
16th, we will assist a lot.
We will have it on 4th March.
She will be retiring soon. They are like 22.
No, what is that? If she is retired also, it will not make any difference. If you succeeded, you will get it back, everything from the date.
More than the benefit she wants to serve. She is a Fulbright scholar.
Yes.
They should be proud of her.
July. You will have it on. Yes. 20. 4th March. Yes.
This is short man.
25th.
Please.
25th. Yes. We'll post this matter for final disposal.
In the IA stage, your lordships may have it.
Let it be in the state.
Yes, it's a short matter.
Yes. Post this matter on 25th. Yes. Is it until further orders is there? I don't think. Not interim order granted earlier is extended till next date of care.
The understanding is we will argue.
Yes, yes, let us. Now that application for vacating, he is also admitting that the reason for is filing an application. Yes. Now that by filing an application, you have placed this matter before this court early. That's all. Nothing else in there. Yes, yes.
Yogesh Kumar.
Yes. IFR vacating filed by whom? Yes. What is that interim order passed in? What is this case? Yeah. Yes. Now you also want time. That is your application for vacating. Yes. At the request of parties, release this matter after 2 weeks. Interim order granted earlier is extended next week.
Number 35, BN Jayadeva for petitioner.
I apply for the petitioner in the connected matter, my lords.
Number 35.
I appear for the petitioner in the connected matter, my lords.
I appear for the petition, the connected matter, my lord.
5.1. Yes. Yes. It's 35.1. Yes, yeah. Yes, sir. I thought that you want any further modification of interim order. There is no. Then he wants time, then we'll yes. Yes. Yes, yes. Yes. How much time you want? Yes. At the request. Yes. Yes, let us see that. Yes. Yes.
at the request of respondent, release this matter next week.
My lords, interim order may kindly be extended, my lords.
Order
I appear for the
granted.
petitioner in 5346 of 2021, my lords. Interim
Yes.
order is only till this date of here.
Both cases interim order granted earlier is extended next date of it.
Much obliged, my lords.
Number 36, P.A. Karumbaya for petitioner, T.N. Raghupati.
In serial number 36, I appear for R4 to R7 on behalf of T.N. Raghupati, sir.
Yes. Yes, madam. What is this? Yes. 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 Now that, which is that order which has been, acquisition has been passed? Two, 24045 of 2000. We have to also award is not passed, that's also it holds that entire acquisition proceeding could lapse. Against this appeal has been filed. Yes.
They filed petition.
Challenging this order. This order, yes.
That petition was dismissed.
Yes.
Against which intervene was
Yes.
intervene is allowed and thereby remanded to.
Where is their petition?
Petition is not included here.
Now, where is that? Who is leading the?
One submission.
Yes.
For R4 to R7 notice may kindly be, sir. We do not have any papers with us, nor any instructions as of now. Yesterday, once the matter was listed, we came to know about this.
Yes, yes. See, that writ petition 24045 of 2000. They have filed a writ petition challenging this order, reviewing of this order. Yes. Filed separate writ petition. What is their relief in that writ petition? What they sought? That is what they are seeking, that review. Yes. What that review has been dismissed. No, that is what Supreme Court said. Person who has interested is not made a party. You can file a writ petition seeking the review of that order. That is actually review. Yes. That writ petition has been dismissed. They have filed a writ appeal. Writ appeal. What is the order of the writ appeal? Give me.
Now the local authority has taken a decision.
Now that repetition order passed by this court on 24 on the repetition 24045 now is by way of that division bench order, it has gone. Now that it is a fresh repetition, you are challenging that acquisition. Now that court division bench said you include that beneficiary and pass it. Now you have made that beneficiary as a party here. Yes, sir. Yes. Yes. Yes.
Now the acquiring authority have decided to purchase the land of the petitioner measuring 38 meter
Yes.
out of 1 acre 28 meter. And we have also agreed for that. They agreed to pay 40 lakhs rupees per acre and totally 152 lakhs.
Yes.
And we have also given consent saying that we will give up the remaining land will be with us.
Yes.
So now in turn the Tahsildar and the Assistant Commissioner has written a letter.
Yes.
We have to withdraw this petition.
Yes.
So I will produce the documents along with the application.
Yes.
1 week time may be granted. Meanwhile, I will send a copy to my learned sister.
Yes.
And I will produce the document. So that the matter will be concluded.
Yes. Next week.
Yes.
Yes. At the
the request of parties, release this matter on 17th October. Yes. You get the instruction. If the matter is settled, then you will register.
Number 37, Prakash DR for petitioner, A. Nagarajappa.
Yes, Prakash.
Number 37.
Prakash GR. Order directing the case may be restraining the respondent from taking any steps to demolish the scheduled property or of any person thereof. Yes, who is appearing for that? Yes.
Number 37.
Yes. What is this, mister? This is old matter. What is this? How they acquired this land? Restraining the respondent from taking any steps to demolish the scheduled properties, any portions of 15, yes. Unauthorized building on the roadside which are on the government land by an required to be evicted, but the building through constructions on the roadside but private properties should not be evicted. If such buildings are required to be evicted for a road development, necessary action will be taken after following the due acquisition proceedings. That is what that we also said. In terms of that, I will dispose of. Their prior is also safe. Yes. This repeats. Now, given circular issued unauthorized building on the roadside which are on the there is directions issued by the government saying that even unauthorized this thing in that roadside also, that is a law. You can't take any position without due process. That is also that your circular issued by that government. If you want to take the position, you do it in accordance with this petition. The petitioner has sought the following relief. Three facts of the case are that they are not mentioned that what is the property and all. It is that property belongs to them. Yes. Yes. Petitioners three are the absolute owner. Petitioners are the owner of the case of the petitioners that they are the owner of petition scheduled property. The apprehension of the petitioners that guise of widening that highway, the respondents, without following due process of law, they are demolishing their property. Hence, they approach this court seeking the above prayers, seeking above relief. But outside, government advocate appearing for state has submitted that if government requires to take if government wants to widening the highway and if want to take any portions of the property, belongs to the petitioner. The position will be taken after following due process of law. He further submitted that to that effect, Secretary to the Government, PWD has issued a circular that has been produced as Annexure C. The portion of the order has been extracted below. Necessary extract. In view of the above repetition is disposed of. Directing the respondent if respondent requires to schedule property to public purpose, or widening of the road, they have to take the possession after following due process of law. Without observation, the writ petition is disposed of.
Bill number 38, 39 action, bill number 40, Ravi HK for petitioner, A. Hanumantappa, Padmanabha Gowda, M. Shivaprakash, Kempanna.
Yes.
Serial number 40, my lords. I am appearing for respond number 2 and 4, my lords.
Yes.
2 and 3, my lords.
Yes, yes. What is this?
Release of compensation in favor of wrong persons.
Yes.
Petitioners given the law
Yes.
are the legal heads of one case Mehboob.
Yes.
Case Mehboob was the absolute owner of
Yes.
land measuring 2 acres 21 guntas.
Yes.
In survey number 47/2 of Godi Bantara Halli village.
Yes.
Acquired the property by virtue of a registered sale deed dated 25/6/1975.
Yes.
Subsequent to acquisition, the Lord, he was in possession and produced all the revenue records reflecting the name of K.S. Mehboob. The said land was never converted, never encumbered in favor of any persons.
Yes.
During the lifetime of said Mehboob.
Yes.
Later, Mehboob passed away in the year 1990.
Yes.
Subsequently, the revenue entries got mutated in favor of the petitioners.
Yes.
Since they are the legal representatives of Mehboob.
Yes.
I produced a mutation register extract.
Yes.
So the matter stood thus.
Yes.
For purpose of widening of National Highway.
Yes.
NH-75.
Yes.
A portion of the land belonging to Mehboob was acquired.
Yes.
To an extent of 1,480 square meters.
1000.
By the notification dated
Yes.
14/11/2007.
Yes. 14/11/2007. Yes.
In the said acquisition notification, name of Mehboob was shown and the acquisition was notified in the name of Mehboob. Although the same was notified in the name of Mehboob,
Yes.
the compensation was released in favor of the respondents 4-2.
Who are there?
The private parties.
Yes. No, they are nowhere connected with your property.
They are nowhere connected.
Yes.
Although my land was acquired,
Yes.
compensation was paid to respondents 5-8.
Yes.
And the claim which they make is
Yes.
we are the owners of certain sites in the said survey number.
Yes.
Based on which we have claimed compensation. However, the notification was in the name of Mehboob. The elders of Mehboob have made a representation for release of compensation. The
Yes.
same has been misdirected in favor of respondents 5-3.
Yes.
This is the brief background of the case.
Yes.
The elders of Mehboob have made representation seeking rectification of the same mistake.
Yes.
And release of compensation in their favor.
Yes.
The same has not been considered.
Yes.
On the other hand, an illegal endorsement has been issued dated 28/7/2014 by Annexure B, saying that your land is not identified at all, therefore compensation cannot be paid to you.
Yes.
Once the land is notified in the name of Mehboob for acquisition,
Yes.
there is no justifications in saying that land is not identified, therefore compensation cannot be paid.
Yes.
Therefore, the act of the respondent number 1 authority in acquiring the land of Mehboob and giving compensation to some third
Mr.
person.
Ravi, so far that amount is not released in favor of respondent.
A portion of the amount according to them has been released insofar as
Now, when that property cannot be identified, how can they release that amount?
that is the illegality, that is the mischief which they have to justify.
For you, they can't identify the property. For them, they can identify it and release that amount.
That is the illegality.
Yes.
Therefore, I am before my lords
Yes.
seeking direction to the
Now,
respondent.
is that award has been passed in that in respect of that property?
But, that has not been notified to us. Only acquisition notification was issued.
Yes. Who is appearing for that government? Who is that land acquisition officer?
Respondent number 2 and 3, my lords. National Highways Authorities of India has acquired this property, my lords.
Yes.
The brief facts is that 3A notification was passed in the year 2006, my lords.
Yes.
Thereafter, 3D declaration also passed in 2007.
Yes.
And award was passed in 2008, my lords.
Award is passed in whose favor, Mister?
In favor of the landowners.
Huh?
Because
In
in
favor of-
1983, because the petitioners has not produced any documents as on the date of award, my lords.
Yes, it is passed in his whose favor?
In favor of landowners who were holding respective lands during that period of time, my lords.
Now, who is the
That is
landowner?
respondent number 4, 5, 7, and 8, my lords.
What is the documents they have produced to show
They
that
have
land?
produced the documents, they have produced the identification
No.
documents and all revenue documents they have produced, my lords.
They may be convinced you. You have to satisfy the court. Show the documents.
Please,
What
my
is-
lords, I have not produced those documents. I will arrange to produce those documents.
That is
2
what
weeks
the-
time maybe.
No, Mr. Srinath.
Yes, my lords.
Land is acquired in favor of, in the name of A.
Yes, my lords.
When passing that award, how can you change that which is law which is provided to you?
As per the revenue documents, my lords.
No, that if the revenue records is stands in somebody's name, why you have shown that petitioner?
Petitioner could not produce any revenue documents in respect of.
No, Mister, producing the petitioner is later. After verification, you have issued a notification in the name of
Please, my
petitioner.
lords. Yes,
Then you will issue a notice to that petitioner to pass an award.
please, my lords.
You will ask him to show that records.
Please.
Not how the third respondent will come to that picture. You show me that, you bring the records and show me.
Please, my lords. 2 weeks time may be granted, my lords. I will bring all
What
the
is that
records.
award amount, Mr. Srinath?
Please, my lords.
What is that award amount?
In my statement
much
of
is-
objections in paragraph 2, my lords, I have detailed the details of the parties to whom amount has been dispersed, my lords.
No, you may be dispersed. On what basis you have dispersed is the question.
Dispersed on revenue documents and possession, my lords.
If you produce, what are the revenue records which has been
Please, my
produced?
lords, I will produce all those documents, my lords.
53 lakhs. Is there any interim order not to release any further this thing?
No, it was way back in 2010, the amount was dispersed, my lords.
Entire amount has been dispersed.
Dispersed, my lords. Under indemnity bond also taken, my lords, and they are also parties to these proceedings, my lords.
Indemnity bond has been taken. Yes.
Please, my lords. All the necessary documents has been executed and
Why you requested indemnity bond? You are not requesting indemnity bond in all cases. When you have
normally as a matter of procedure, all the while dispersing amount, it's been taken.
Yes, Mr. Counsel, who is appearing for other respondent 5, 6, 7? You are. Yes.
Compensation has been dispersed only so far as 495 square meters.
Yes.
The remaining portion, the compensation was not dispersed.
Now, who is appearing for that other respondents?
Shiva Prakash.
Yes, where is you are appearing for whom? R9. Yes, what is the documents you have to show that you are the owner of the property? On what basis it has been mutated?
And the sibling of this petitioner, respondent number 9 is saying with the petitioner.
He is your this thing. Yeah. No, but for him they have released that amount. You are not released. You are selling with that petitioner.
Petitioner.
Yes. Where is Shiv Prakash? Yes, when will you produce, Mr.? You produce the records.
Please, my lord, say 2 weeks time may be granted. A date may be fixed. I'll produce those documents, sir.
Yes, yes. Yeah.
It was issued on 8/4/2015 only with respect to 495 square feet. The award has been disclosed, and with respect to 771 square feet out of the total 1,480 square feet,
yes,
the amount has not been issued. And they have even further admitted that it is a waiting plan.
Yes, let us see.
Hence,
Now let him produce the records. On what basis they have released? Let me see that. What are the records which has been produced? We don't know that they may be created some records, or they may be purchasing the property from you. Let me see that records. You
Please,
produce
my lord,
that. When, Mr. Srina?
My lords, 2 weeks time, any date may be fixed after 2 weeks, my lords. I'll produce those documents, my lords.
22nd.
Please, my lords.
Yes.
they have not released the whole amount insofar as the remaining extent. It is for an observation that.
Now he said that the entire amount has been released.
All them, I've stated in my statement of objections, my lords.
In the statement of
in paragraph 2, my lords, the date of disbursement payment also is being given, my lords.
Where is that paragraph?
Paragraph number 2, my lords, in my statement of objections. Respondent number 2 to 4, 2 and 3.
Yes. 2 and 3, yes.
Yes, paragraph 3, there is a column provided, my lords.
Yes. Yes, they have mentioned. What are the
extreme last 2 columns, my lords, compensation paid and date of payment, my lords.
Yes. Now you have not stated that on what basis you have released that amount.
As per revenue documents that I have stated, but documents not been produced.
Yes, that is the crucial point. Produce me
Please,
that
my
document.
lords, I will produce those documents, my lords.
Now, even then, if RTC is in their favor, but land has been acquired in the name of so and so, can it be released that amount?
Yes, my lords, because even the building construction buildings were there in that property.
That provision later, yes. Okay.
I will take your lordship through those provisions as well, my lords.
Are claiming compensation or signs the lands have never been converted.
Now, let me see on what basis they are claiming, whether they have produced any sale deed and all. That they let them show. Otherwise, we'll ask them to this thing. Anyhow, they have given an indemnity bond. Encash that, and if you succeed, then you are entitled. Yes, 22nd.
22nd. Much obliged, my lords.
Number 41, Narendra Babu for petitioner, R. Ramanjane Gowda.
Lordship, I appear for respondent BDA, Lordship. Praise a week's time. Today the matter was entrusted to me.
Yes, who is?
Kiran CV, appear for respondent BDA, your Lordship.
Now that Ramanjane Gowda is not there.
He is not in the panel, and the case has been entrusted to me. Today they have informed me. So praise for a week's time, your Lordship. I filed the Wakalat, Universal Wakalat, and also the necessary.
Is the why that his name has not been directed to? Yes. Office is directed to delete the name of R. Ramanjane Gowda for respondent number 2 and 3. Show the name of Kiran CV, na?
Kiran CV, your Lordship.
Show the name of Kiran CV, counsel for respondent number 2 and 3. At the request of Kiran CV, release this matter next week. Yes.
Much obliged, your Lordship.
For petitioner, Ramachandran, Raghavan Gayatri.
Yes.
Serial number 46.
Yes, 42.
My lord, I appear for the seventh respondent, my lord.
For respondent number 2 and 3, my lord, in this case. 3 and 4, my lord.
Yes. Yes, Mr. Badri.
That seventh respondent retired from service, my lord, on 31/12/2021, my lord.
Wait, Gayatri, let the petitioners make submission. Yes.
I'm sorry, ma'am.
I'm sorry. Yes. 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 Whose term is completed? Respondent. Yes. In this petition, petitioner called in question with selection or appointment. Appointment of respondent number 7 as a director from dean for a period of 2 years, for a period of 2 years. Since the term of respondent number 7 is completed on 6/11/2021. Complete agada 2 years. 21.
2 years till retire. I'm sorry, my lord, I make submission. Till retirement, my lord, she retired from service on 31/12/2021, my lord.
31/12/2021. He has been appointed as a director from Dean, Bangalore Medical College and Research Institute. The seventh respondent has attained superannuation on 31/12/2021. In view of the above, the relief sought by the petitioner will not survive for consideration. Accordingly, the writ petition is dismissed as become infructuous.
Please.
Please, ma'am.
Accordingly, writ petition is disposed of. Yes.
Madam, my lord, only one submission, lord. Appointment by selection. Appointment by selection.
Yes. Yes, appointment by selection. Yes.
Please.
Yes.
Lordship, in this case, I am appearing for petition, my lordship.
Yes.
Lordship, in this case, kindly come to Annexure C, Annexure S, page 96, my lordship.
Yes.
The BDA has recommended to the government.
What is the case? First,
Case is, my lordship, that I am challenging the notification 1961 issued by the former CITB. In this case, petitioner land as award was not passed, possession was not taken. BDA in 2007 recommended to the government that we are not utilized, we are not passed any award. Annexure, yes, my lordship. After that, this court has passed, given a direction. Kindly come to order sheet, my lordship. Order sheet passed by this honorable court.
Yes. Which is the date of order?
Lordship, since from 27/10/2021. And
27?
finally on 8/2/2021, this court passed an order from the perusal of the order sheets. It discloses the conduct of the respondents in not complying with the orders passed by the court. Hence, in order to comply with the aforesaid orders, finally 1 week time is granted, subject to payment of cost of ₹5,000 to the Karnataka State Legal Services Authority. Both respondent 2 and 3, this court passed an order, and 8 to 10 hearings, they have not complied the order of this honorable court, my lordship. And
Yes, Mr. Ulikrishna, what is that order? When you enter?
This connection is relied upon by the petitioner, wherein there is a noting saying that this land may not be utilized and it can be handed over, etc. Reference to be made to the government. Now, my lord, when this matter was taken up, this honorable court directed for further action on this, as what has happened in constituency with that noting in the BDA. My lord, friend is right to a point saying that the court might impose cost, but subsequent probably he is not aware. We have filed an affidavit before this honorable court stating that land still rests in the BDA, we are not taking any actions. The submission, my lord, is that as far as that particular noting is concerned, my lord, last application I filed a citation.
No, now that his case is no, his case is that scheme is lapsed under section 27.
No, this was an acquisition under the Mysore Land Acquisition Act. CATB.
Yes. There is no any provision for lapsing.
There is no provision of lapsing. In fact, my lord, this is the second round of litigation. I produced the judgment also. The very same survey number, my lord, in 1961. This particular land was acquired for the CATB. Petitions were filed in the year 1997. And in 1998, a specific finding of fact that this particular land has been acquired by the BDA, now BDA, position taken, and the entire finding of fact has not been.
No, which is that who has filed this writ petition?
These were filed by some of the persons who claim to be in possession of those lands.
Yes, in respect of the very same land.
Very same survey number. And many other survey numbers.
Yes. Where is that order passed by?
I produced that order in my list of judgments produced on 24/1/2022. It was filed in the counter, but not it's there.
Yes.
In the statement of objections also, I take this very same contention.
Yes.
I'm not trouble, my lord, will kindly see page 9 of it.
Now, what is that which has challenged in the?
Then, my lord, he is now what has happened, my lord, in 1960 itself,
yes.
The entire acquisition was complete.
Yes.
He claims title to one Mr. Kariyappa.
No, that I will come. Now, what is that which has challenged in that earlier writ petition? Acquisition only. Yes. No, that acquisition has been upheld. Now that he can't challenge that acquisition.
Exactly.
Now the question is whether is there any provision like now that is there any lapsing?
My lord, there is no such provision of lapsing in the act, which now, my lord, has been repealed after the promulgation of the Act of 1976, the BDA. The BDA Act, my lord, holds the field. There is this lapsing under Section 27 all have come in this new act.
No, that's what that. Is there any provision under the old act for lapsing, or that under the repeal provision? Is there any right has been?
Yes, only as far as CATB, the act provisions of CATB has been saved.
But CATB Act, there is no provision for lapsing.
There is no. In fact, in CATB, there is no provision for acquisition.
Then how?
Unlike in BDA Act, it's a self-contained code,
yes.
Where it also provides for acquisition under 1719,
yes.
The self-contained code, and acquisition, as the Honorable Supreme Court says, is incidental to development. That CITB was only for development.
Yes.
Their acquisition had to be done to the Mysore land acquisition.
Yes.
Is not there. Now, his grounds, two grounds before this Honorable Court is one thing is under Section 24 of the new Act of 2013.
Yes.
Which is on the Supreme Court has tried and again said that
yes.
it doesn't apply to state enactments. It's probably acquisition under the 1894 land acquisition act.
Yes.
It doesn't apply to any state. Now, as far as this acquisition is concerned, there is a specific finding of fact that land possession has been taken, acquisition is complete. When that finding of fact has attained finality for more than so many years, it cannot be achieved by him. He was a subsequent purchaser. Is my submission.
No, when he has purchased, he is a subsequent purchaser.
In fact, even his seller does not have to demonstrate.
No, even see, he has purchased from the persons whose name is there in that revenue record. In that.
The owner was Gosai.
Yes.
No, my lordship. No, my lordship.
Wait. Yes.
The owner was Gosai. What happens is, in the year 1960, the entire acquisition is done with it.
Yes.
In the year 1976, he files a petition before the special.
Yes. Now, Mr. Malikarjun, ready? You argue this matter. No,
lordship, in this case, possession was not taken. No award has been passed in respect of survey number petitioner's land, my lord. Yes, my lord.
Mr. Counsel, don't argue like that piecemeal. If you are ready, you argue that matter from the beginning. You say that fact.
Yes, my lordship.
Yes.
Lordship, petitioner has purchased the land. Earlier, the land was there is a the case is pending before the special DC, my lordship, Inabulation Act. The deputy commissioners granted the land in favor of one Raja Lakshmi, my lordship.
Raja Lakshmi.
Yes, my lordship.
Yes.
That is in the year
yes.
19 that is in the year 1977, my lordship. The property,
1977.
yes, my lords. After that, they are paying tax regularly.
Yes.
And the land was handed over to BBMP, and they are paying property tax and also Kata certificate. The petitioner purchased the land from them in the year under a sale deed.
When?
In 2012, 2019, my lords. I'm sorry, my lordship.
20?
That is 2007, my lordship.
Tell me the date, mister. Yes, you know the date, mister.
This particular
27/8/2012, my lordship.
Wait, your counterpart will give that facts.
Yes, my lord. Yes, my lord.
Facts of the case of the petitioner is that
Yes.
one Mr. Kalaya was granted occupancy right with respect of this property bearing survey number 69 of the Vipra.
Alaya. Occupancy rate.
Yes. Order dated 30/1/1979 of the Special Deputy Commissioner for Abolition of
37? 30?
1979.
1979. Kalaya is the original owner.
Yes. And the land belonged to
Inam land.
Land belonged to Gosai Vipra.
Yes. Yes.
Then this Kalaya, he's no more. He passed away. And on 30/6/1989,
Yes.
he sells it to B.A. Rajalakshmi.
1989. Yes.
Subsequently, this Rajalakshmi sells it to
It is.
Lakshmamma.
Then
The deed is not produced, but it is sold because there are deeds in breeding.
Lakshmamma. Yes.
Then Lakshmamma sells it to the petitioner on 19/1/1989. That is produced at
89.
6.
Yes.
Annexure L.
Yes.
Now he has
When that property has been acquired?
1960, before this Inam.
1960.
Annexure A. He has only produced it. That is dated 9/1/1961.
9/1/1961. This is after the acquisition. What is this?
After acquisition only, he has this occupancy rights has been granted in favor of this Kalaya and subsequent transactions. And this person is now the latest purchaser who has transferred revenue record, BBMP Kata.
How that it can be done after acquisition? Revenue records stands in his name.
I don't know. That is something which, even if it is true, it has no right.
Yes. Yes.
Land just with the CH-13, then the BD.
Yes.
Now, some of the petitioners had filed a petition challenging the very same acquisition of the BD, of the CH-13.
Yes.
My lord, may kindly see the judgment passed in 34096 to 34150/97. That is page number 1.
Page number 1. Page number 1.
Page number 1 citation. 24/1/2003.
Yes.
There was a citation in 2 volumes. First volume was on the section 24. Lord, I'll take my lord straight away to page number 9 of it.
No, this
Very same survey.
no, that which is that judgment you are referring? Srinivas Gupta and others.
Srinivas Gupta and Sampurnam.
Huh? Oh, this is another one. You are given the 2 volumes.
2 volumes.
Yes.
I have not furnished a statement of objections copy, my lordship.
Yes.
In written statement, I have taken the very same stand.
Yes.
My lord, we kindly see paragraph 2.
Yes.
It says the petitioners in this petition under articles also issue a written mandamus, the nature of mandamus, and so on so for directing the respond to regularize occupation petitioner in accordance with their respective holdings in land bearing survey number 69 is one of the lands.
Yes.
And 58 and 56, as well as to declare that the respond number 3 is a stranger over the properties bearing 56, 58, 69 of the Vipura village in the wake of acquisition by the erstwhile CITB and grant of such other leaves.
Yes.
Then, next page.
Yes.
Paragraph 3. Case of the petitioners is that the petitioners are the permanent residents of area known as Gavipram, formed in survey number 56, 58, and 69 of the petitioners further case that petitioners 1 to 32 and 43 to 44 are residents of survey number so and so, and remaining petitioners are the land in survey number 58 and 69.
Yes.
That is belongs to one Gosai Mutt, but the same has been acquired, and after acquisition of those survey numbers, it is culminated in award being passed and compensation being paid to the said Gosai Mutt by the erstwhile CITB, presently known as BDA. Petitioners have annexed A, which is a true copy of certification of the award and vesting of possession in the special land acquisition officer CITB Bangalore. Petitioners are further stated that there's another survey number. Then, while disposing of the petition, this honorable court, my lord, at page 25.
Yes.
Line 1, 2, 3, 4, 6 lines from the top. If the conception did come within the purview of section 4, the unauthorized conception cannot be regularized. Petitioners are clearly aware that regard to survey.
Yes, which where you are reading?
Page number 25.
25. Yes.
If the conception did come within the purview of section 4,
Yes.
the unauthorized concession cannot be regularized. Petitioners are very clearly aware that as regards survey number 58 and 69, that is this property, that the said lands have been acquired by annexure A, which reveals acquisition to have been made sometime in 1960, and it has also been admitted in para 11 that award and vesting of ownership in the hands of the City Improvement Trust Board has occurred in 1960 itself.
Yes.
So, in my opinion, so far as construction and so are concerned, petitioners will not be entitled to leave.
Yes.
So, there is a clear finding of fact that time itself which has attained finality as far as vesting is concerned. My submission is the Honorable Supreme Court Indo that authority would say, and an issue which has, even though raised in a different person, as far as acquisition is concerned, would operate as res judicata for subsequent actions also.
No, that is not the issue now.
No,
He is also not disputing. Land has been acquired.
Now he says,
Yes.
and it goes back. Now let us say if there is lapse for the second. I would say,
Now that is the issue. No, this judgment.
my submission is,
Yes.
even if there is lapsing, acquisition would not lapse. And this honorable court can also take division of the fact. This is very important. It's a heart of the city. It's a scheme which has been.
That is the only issue now. Whether you have implemented that.
I will implement this.
Yes. Have you stated where is that?
I stated that in the statement of objections.
Yes.
Apart from the issue of limitation,
Yes.
then the issue of suppression of fact is filing of statement. Another solution would be
Yes.
when the land has already been acquired by the CATV,
Yes.
his predecessor Kalayan, original owner, could not have been conferred with occupancy rights because Gosai Mutt was not called the owner. So even if he was in possession, cultivation.
No, that in notification you have shown that Gosai Mutt.
Yes, Gosai.
Yes.
Annexure A. Not if kindly see annexure B, sorry, the annexure A.
Yes.
21. Sorry, 22. Yes, sorry. Gosai Mutt is the owner.
22 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
Gosai Mutt, Sajjan Rao, and others. This is all the Vivipuram area.
Survey number
69.
69. Yes. Gosai Mutt. Yes. Yes.
It says Gosai Mutt, Sajjan Rao, and others. So this particular area, which is now Gavipuram, which is now known as Vivipuram area, this completely their scheme is implemented.
Yes. Where is that your the statement in that objection that scheme has been completely implemented?
Another submission is that he says that the scheme has lapsed under 24. That's what he is saying. And my submission
No,
is
Mr. Unikrishna, we will come that later. If scheme is already implemented,
Even then, if he satisfy the courts that there is a provision for lapsing, that benefit will not available because scheme is already implemented. Therefore, first you convince the court that scheme is implemented. Where you have stated in that objection. Where is your objection, Mr.? That objection is not filed. It's not available in that court.
They have not served even copy of the objection statement, my lordship.
How you are raising this objection, Mr. Rao? You have not served the copy.
They are not served.
No, it is not in that court copy also. Not filed anta bandide, Mr. Where is that acknowledgement for filed this in the court? ಮೇಲಲ್ಲಿ ಹಾಕಿ ಮೇಲಲ್ಲಿ ಕಳ್ಸಿದ್ದೀರಾ? What about the petitioner? Yes, Mr. Mallikarjun, he has sent it through that mail.
No, my chief, annexures he has not sent there. He has sent only objection statement. What he is relying upon, he has not given anything.
No, that is citation and all. It need not be furnished to you.
And he has said so many things, my lordship. Annexures. Annexures, he said so many annexures. He has not given me.
No, that objection again annexures. Yes. No, he has not furnished by any annexures along with that objection, Mr.
Yes, my lordship. In this case, no award has been passed. My learned friend, if the award is passed and possession is taken, I have no case at all. Even the scheme is not at all implemented. I am in possession. I am in possession.
That is the. Yes. ಬಂದಿದೆಯಾ? Is it you have produced any document to show that award is passed? Yadralli. You produce that. That is what this case also. Yes, when do you want? Only that records has to be produced. All that. Yes. 22nd. 22nd. Yes. No. That will come to that. When petitioner himself is admitted that if the award is passed, I don't have any case. Why do you want go to that all these things? If it is award is passed, then we will come to that. If he has any other ground, then whether he has any right to challenge, then whether it is any lapsing and all will come later. Yes. That is true. There this court held that it is all concluded. That you have to place that records to me. Yes. What is second? 23rd. Yes. Yes. Yes.
Number 44. Savita YS for petitioner, B.B. Patil, and then Naresh.
I appear for respondent number 2 and 4 in this matter.
Yes.
For respondent number 3.
Yes. Savita YS, who is that?
Number 44.
What is this, Mr. Harish?
Right. Internally, one portion of the property was acquired.
Yes.
And they are demanding that the remaining portion should also be acquired. So now we had made an offer.
Yes.
We said that we will pay in accordance with the government value, but
Yes.
they'll not be entitled to any solatium or interest.
Yes.
If they're interested, then we can purchase it because it cannot be a question of compulsory acquisition.
Yes.
But they refused. They refused to accept that offer.
Yes.
And now
Then
they want to be compulsorily acquired.
Yes, that they cannot do it.
demand. Yes, they cannot demand compulsory acquisition. If necessary, we'll purchase it by paying the market value fixed by the government.
What is that annexure A? That is your
Annexure
offer.
A is an endorsement that we had given.
Yes.
Additionally, we say that there are earlier proceedings also.
Yes.
We were asked to consider his representation, which we have considered.
Yes.
Additionally, second parallelly now ಹೇಳ್ತೀವಿ that ಅವ್ರಿಗೆ offer ಕೊಟ್ಟರು they refused ಅಂತ ಹೇಳಿ. I have also produced that offer letter where I have said 46,888 rupees per square meter we are ready to offer ಅಂತ. But they have refused to accept that.
Yes, where is that? Who is that Savita? None appear for the petitioner. Where is this matter next week? Yes.
45 adjourned. Till number 46, Leela P. for petitioner. Yes, Mahesh.
Yes.
I appear for the sixth respondent.
Matter relates to the petitioners who are working as water boys in various municipalities.
Yes.
They have sought for equal pay.
Yes.
Equal work, equal pay is the demand. That municipalities employees identical work they are carrying on, they are getting higher pay scale.
Yes.
You are not getting equal pay. Secondly,
Yes.
they demand that in terms of the government's order prohibiting contract labor, in terms of the Prohibition of Contract Act Section 10, government has passed orders, 2 orders, Section E and E1.
Yes.
You abolish the contract even with respect to municipalities.
Yes.
And directly deposit the payment to us.
Yes.
So we are entitled for equal pay in terms of municipal corporation Paurakarmikas or municipal corporation water boys.
Yes.
And for this has been rejected with with an order which I have impugned in this writ petition.
Annexure K.
Annexure K.
Yes. What is that?
No reasoning, no application of mind, absolutely no consideration of the government orders, court orders, or the prevailing legal position. Kindly see Annexure K.
Yes. Read.
ಬೀರೂರು ನಗರ ಪುರಸಭೆ ನೀರು ಸರಬರಾಜು ಶಾಖೆಯಲ್ಲಿ ಹೊರಗುತ್ತಿಗೆಯಲ್ಲಿ ನೀರು ಸರಬರಾಜು ಸಹಾಯಕರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ನೌಕರರಾದ ನೀವು ಉಲ್ಲೇಖ 2ರಂತೆ ಈ ಕಚೇರಿಗೆ ಮನವಿ ಸಲ್ಲಿಸಿ ಉಲ್ಲೇಖ 1ರಂತೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಬೆಂಗಳೂರವರ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ದಿನಾಂಕ 5/3/2018 ಆದೇಶ ಪ್ರತಿಯನ್ನು ಲಗತ್ತಿಸಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಸಕ್ರಮಾತಿಗೊಳಿಸಿ ಸಮಾನ ಕೆಲಸಕ್ಕೆ ಸಮಾನ ವೇತನವನ್ನು ನೀಡುವಂತೆ ಕೋರಿರುತ್ತೀರಿ. ನೋಡಿ, ಐ ಹ್ಯಾವ್ ನಾಟ್ ಆಸ್ಕ್ಡ್ ಫಾರ್ ಸಕ್ರಮಗೊಳಿಸಿ. ದಟ್ಸ್ ನಾಟ್ ಕರೆಕ್ಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್. ಆದುದರಿಂದ ನಿಮ್ಮ ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ನೀವುಗಳು ಬೀರೂರು ಪುರಸಭೆಯಲ್ಲಿ ಹೊರಗುತ್ತಿಗೆ ಆಧಾರದಲ್ಲಿ ನೀರು ಸರಬರಾಜು ಶಾಖೆಯಲ್ಲಿ ನೀರು ಸರಬರಾಜು ಸಹಾಯಕರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ನೀವುಗಳು ದಿನಾಂಕ 1/4/2006 10 ವರ್ಷಗಳ ಕಾಲ ನಿರಂತರವಾಗಿ ದಿನಗೂಲಿ ಆಧಾರದಲ್ಲಿ ನೀರು ಸರಬರಾಜು ಶಾಖೆಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸದೇ ಇರುವುದರಿಂದ ನಿಮ್ಮಗಳನ್ನು ಸಕ್ರಮಗೊಳಿಸಲು ಉಮಾದೇವಿ ಪ್ರಕರಣದಲ್ಲಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಕರ್ನಾಟಕ ರಾಜ್ಯದಲ್ಲಿ ಚಾಲ್ತಿಯಲ್ಲಿರುವ ಕಾರ್ಮಿಕ ಇಲಾಖೆಯವರ ನಿಗದಿಪಡಿಸಿರುವ ವೇತನ ಮತ್ತು ಭತ್ಯೆಗಳನ್ನು ಒಳಗೊಂಡಂತೆ ಹೊರಗುತ್ತಿಗೆ ಆಧಾರದಲ್ಲಿ ವೇತನವನ್ನು ಪಾವತಿಸುತ್ತಿರುವುದರಿಂದ ನಿಮಗೆ ಸಮಾನ ಕೆಲಸಕ್ಕೆ ಸಮಾನ ವೇತನ ನೀಡಲು ನಿಯಮಾವಳಿಗಳಲ್ಲಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಈ ಮೇಲಿನ ಎಲ್ಲಾ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನಿಮಗೆ ಸಕ್ರಮಾತಿಗೂ ಹಾಗೂ ಸಮಾನ ಕೆಲಸಕ್ಕೆ ಸಮಾನ ವೇತನ ಅಡಿ ಪರಿಗಣಿಸಲು ನಿಯಮಗಳಲ್ಲಿ ಅವಕಾಶವಿಲ್ಲವೆಂದು ಈ ಮೂಲಕ ಇಂಬರ ನೀಡಿದೆ. Equal pay, equal work for equal pay, not is a fundamental principle. Is the first principle of law. Well settled by 10 of judgments of this Honorable Court and the Honorable Supreme Court.
Yes.
Can an authority say that there is no not a rule which provides for it? But I am entitled for it not as a mandate of law.
No, that
Kindly see the proceedings, not. I'm
no,
sorry.
that word Horaguttige, you are not an outsources.
No, I am on contract. I am
You are on contract, not
I'm on-
outsources, not outsources.
Not outsourced, not outsourced. But not contract.
It is outsourced. It is outsourced. They are
Abolish-
working under the contractor. I may be permitted to file my statement of objection. They are neither daily wager nor were they employed by the municipality. The work was entrusted to a contractor based on the tender which was called for, and then he has employed all these persons. So I will place all this on record. The Lordship may give me some time to file objection.
Yes, Mr. Panana, what is?
Not just 1 minute. My earlier writ proceedings, not your lordship may see the direction which was issued, page 136, in page 136.
Yes. Yes.
Para 6.
Yes.
The mandate of Article 14 of the Constitution of India is that the person shall not be discriminated if they are working in similar cadre, and also Article 91D of the Constitution of India mandates equal payment for equal work. In the light of the provisions of the Constitution of India and also in the light of the judgments of this court referred to above, it's appropriate to direct the 6th respondent municipality to consider the representation at Annexure J.
Yes.
In addition to the above, petitioners are liberty to make detailed representation. Now, on this representation, they reject my claim for equal pay to equal work on the ground that there is no provision in law. No, it's a constitutional mandate, is a direction issued by this honorable court.
Now, Mr. Mahesh, why you have not raised this objection earlier that they are not entitled?
No. There was only a direction to consider the representation which you have done. So I'll have to raise all these objections now. Previously, their contention was to consider their representation. So we have considered the representation and we have passed Annexure K. Now I have to raise all these things because in the previous petition, it was only for.
If they are outsourcers, they are not entitled for equal pay in the equal work. You should have objected earlier to issue in a direction for consideration because their application itself is not maintainable.
So the writ petition was only to consider their representation in those writ petitions.
Yes.
We have considered the representation. It is now only now they are raising all these points. All this was not raised in the previous writ petition. And it is the government also which has to consider all these things.
Yes.
A municipality cannot take decision on this. So we have considered their representation and passed annexure. Now I'll have to raise all these objections. Not in the previously, it was only for to consider their representation.
Yes. No, but their prayer is also only for the equal pay, equal work, not for regularization. Why you have referred Uma Devi case?
They have referred it. Their
prayer is only for the salary. Yes.
In their representation, they had referred to it. Yes. And moreover, my lord, your lordship will have to consider.
Now that Mr. Mahesh, now you have to show me that they have been worked under the contract. Your relationship is only between the contract. Then Banana, you have to work out a case. Under that circumstance, you are entitled to pay equal work.
Not in view of the mandate not of the Contract Abolition Act and the government orders this they issued.
Yes.
Not contract labor is not permitted anymore. It is abolished. They cannot claim not that somebody is under contract. A statutory authority, not an institution of the state, cannot claim that. In fact, that is my representation also says that you implement the government order.
Madam, your lordship may kindly give me some time. I'll file a detailed objection
Page,
as to when the contract was awarded and when it was terminated. That is very important in the matter because once the contract is terminated, they are not entitled for anything.
I'm still working. I don't know what my learned friend is saying. Not page 134. Kindly see page 134. The lordship, page 134. This is my first original instance what I have pleaded before this honorable court.
Yes.
Petitioners for this court seeking a writ of mandamus or any other direction directing the respondents to consider the representative so and abolish the contract labor system under section 10(1) of the Contract Labor Act 1970 and to pay equal wages to the petitioners on par with the regular employees of the sixth respondent and other consequential.
Yes, Mr. Yes. You have not answered regarding that in that endorsement.
No, they have a zero application of mine. They have just, what happened was they did not comply with these directions.
Yes.
So I had
Yes.
This honorable court in contempt proceedings not took up the issue seriously. They issued this endorsement to get away from the contempt.
Where is your representation?
Lord, my representation is at Annexure H.
Annexure H.
Yes.
Page?
Not page 138. No?
Yes.
ವಿಷಯ
Yes.
ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ನಿರ್ದೇಶನದಂತೆ ಗುತ್ತಿಗೆ ಪದ್ಧತಿ ರದ್ದುಪಡಿಸಿ ಸಮಾನ ಕೆಲಸಕ್ಕೆ ಸಮಾನ ವೇತನ ನೀಡುವ ಕುರಿತು.
Yes, Mr. Mahesh, on these terms you have to consider whether this can be done. You reconsider and pass an order.
Yes,
you have
that we can do it. Yes, we will reconsider and pass an order.
You have to reconsider their representation in their prayer, not as you like. Yes.
Swami, ಏನಾಗುತ್ತೆ ಮುನ್ಸಿಪಾಲಿಟಿ ಕಮಿಷನರ್ಸ್ ಅವರು ದೇ ಆರ್ ನಾಟ್ ಲೀಗಲಿ ಮೈಂಡೆಡ್. ಲೀಗಲ್ ಮೈಂಡ್ ಅವ್ರಿಗೆ ಇರೋದೇ ಇಲ್ಲ. ಏನೋ
ಇಲ್ಲ, ನೀವು ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ ತಕ್ಷಣ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ
ಆವಾಗ ನಮ್ಮ ಹತ್ರ ಬರ್ತಾರೆ ಅವರು. ಐ ಲಾಸ್ಟ್ ದೆಮ್ ಟು ರೀಕನ್ಸಿಡರ್ ಇಟ್ in view of this representation.
Yes, yes.
Let them give me an opportunity, not so that I can explain what my case is.
Yes, you give an opportunity for them also. They can explain.
Yes, man.
Yes. This petition is filed under Article 226 of Constitution of India, challenging the endorsement issued by respondent number 6, dated 22/3/2019, with annexure K, wherein the request of the petitioner for equal pay, equal work has been rejected. Case of the petitioners that they are working as a contract laborer.
Page number 9. They have themselves stated employees appointed on contract basis under local bodies and avre heltare. Now we have not employed them at all. All right, we will reconsider. We'll reconsider, my lord.
No, Mahesh, they are not disputing that. They are saying that in view of abolition of that contract, this thing, we have to directly appoint me as a contract laborer and pay that equal pay and equal work. That is their case.
We will consider it, and the government also has to consider that, because municipality or madadru kuda sanctions alla madadu government. So directions may be issued. We will, of course, this order annexure K, we will redo it.
I'm sorry, would your lordship see annexure E for 1 minute? Government has abolished it.
Yes.
Government has abolished it.
Yes.
In fact, I was part of this abolished decision making.
Working as contract laborer in 6th respondent town municipalities. The Department of Water Supply and Maintenance as a water supply helper for more than 10 years. 6. The salary paid to the petitioner is less than to the regular employee. They approach this court in WP number 46656-4. They have filed a representation
to the respondent seeking for abolition of the contract labor system, the section 10(1) of Contract Labor's Regulation and Abolition Act 1970, and pay equal wages to the petitioner on par with the regular employee. Since their representation is not considered, they approach this court in petition in 46656-46666 of 2017. This court, by order dated 5th March 2018, has allowed that writ petition, directed the respondent to consider the representation of the petitioner in accordance with law. Pursuant to that, the respondent has issued the impugn endorsement. Being agreed by the same, the petitioner is before this court. Sri A.S. Panana, senior counsel appearing for petitioner, has contended that the petitioner has given a representation on 8/9/2017 seeking abolition on contract labor system under section 10(1) of the Contract Labor Regulation and Abolition Act 1970, and requested them to pay equal wages to the petitioner on par with regular employee of the sixth respondent. In spite of specific directions by this court to consider that representation of the petitioner in accordance with law, that impugn endorsement has been issued rejecting the claim of the petitioner. The same is issued contrary to the directions of this court. The impugn endorsement has been issued without application of mind. In spite of that, petitioner has sought for abolition of contract labor system. The respondent has not considered this aspect of the matter. Hence, he contended that impugn endorsement is not a speaking order. Hence, he sought for quashing of the same. Per contra, Sri Mahesh, learned counsel appearing for the respondent, sixth respondent, has submitted that pursuant to that representation submitted by the petitioner, his case has been considered. Since the petitioners are working, petitioner is working under the contractor. Therefore, they are not entitled for equal pay, equal work, par with the regular employees working in that. The TMC or this thing?
TMC. TMC.
Municipality.
Yes, town municipalities.
Town municipality.
Therefore, the authority has rightly rejected this representation. Government advocate appearing for respondent as, what is your submission, madam? Yes. No, but this is your legislation. You said that contract labor has to be abolished. Then you have to be advised that to CMC to abolish the contract labor. They can't take it as an outsources. ನೀವೇ ಮಾಡ್ತಾ ಇದ್ದೀರಾ, ಗೌರ್ಮೆಂಟ್ ಔಟ್ಸೋರ್ಸಸ್ ಮಾಡ್ತಾ ಇದೀರಿ, ಅವ್ರಿಗೆಲ್ಲ ಹೇಳ್ತೀರಾ. Yes, supported the endorsement issued by the respondent, heard the learned counsel for the parties. The petitioner has given a representation on 8/9/2017, requesting the respondent to abolish the contract labor system under section 10(1) of the Contract Labor Regulation Act 1970, and to pay equal wages to the petitioner on par with the regular employee of the sixth respondent.
since their representation has not been considered, they have approached this court. This court, by order dated 5th March 2018, on 46656-46666 of 2017, has directed the respondent as follows. In spite of specific direction by this court, the impune endorsement has been issued, wherein the request of the respondent has not been considered. Thus, the representation submitted by the petitioner has been produced before this court as Annexure H. The specific prior made by the petitioner is that abolition of the contract labor system under Section 10(1) of the Contract Labor Regulation Act 1970 and seek for equal pay, equal wages to the petitioner on par with the regular employees. In the impune endorsement, there is no whisper about the request of the petitioner regarding abolition of contract labor system. The impune endorsement has been issued without application of 9. The same is contrary to the direction issued by this court in writ petition number so and so. The impune order Annexure K is not in a speaking order, is liable to be quashed. Accordingly, the impune endorsement Annexure K dated so and so is quashed. The respondents are directed to reconsider the representation of the petitioner in accordance with law after giving an opportunity to the petitioner. Yes, within 6 months from date of receipt of copy of this order.
Yes, but your lordship, keeping the provisions of the Contract Abolition Act in.
Yes, yes. That is the reason I have passed, since you have specifically stated, for they have not considered that. Therefore, that endorsement is without application of 9. Now they have to consider strictly in their representation in accordance with law. Then they will give an opportunity. You go and explain them.
Yes, but there are 3 other matters not identical. Exactly, yes. The lordship can connect it today itself and.
Yeah, it is. No, that Mahesh is appearing in all these cases.
No,
if it is which ones, I want to know which municipality.
My learned friend is not appearing. Shall I give the number?
You give that number. We'll post this in on Monday.
16594. 16668.
Yes.
16817. All of 21. 3
yes.
petitions.
165
94 16668 16817. 16817.
Yes. In view of the disposal of the writ petition, IA 1 of 2021 will not arise for consideration.
Ref.
Yes.
Court officer? Court officer?
Madam.
Serial number 59.
59 ಇದೆ madam, ಇದೆ.
Okay, thank you.
Sir, serial number 54.
54 ಇದೆ madam.
Okay, sir. Thank you.
Yes, Mr. Yes. 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 Now, only thing is, he said additional chief engineer. Is it true? That is what that now that yes.
Not the, well, I produced the memo. I'm working like your chief engineer or additional.
Yes, wait, and that matter is called. Then BL Sanjay will come. Yes.
He's online.
No, he's not there. Yes.
First floor matter, number 30, Nagaraj D for petitioner, K.R. Srinivasa.
Yes. Yes. Good one. Yes. Where are you reading? 3. Yes. 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 Yes.
Officer or survey means an officer or employee employed in an administrative, executive, or administrative capacity.
Yes.
Other than those born on Karnataka municipal not persons employed.
Yes.
These rules do not apply to officers and employees, not KMC.
Yes. There is no dispute that. Yes. Yes.
Includes not the method of recruitment, but also creation and abolition of posts by specifying different categories of posts in different branches of service, specifying total number of posts,
Yes.
and the nature of such posts, and scales of the
Yes.
This judgment also refers to recruitment. A lot has said will be only recruitment, filling of office. My submission is 365(1).
Now, what is that recruitment and filling of post? I have not said. I said 365. The word is used. Filling of post, not that recruitment regarding this rule. This rules is not. There is no doubt. This rule is. No, Nagaraj, take it from me. This is framed under section 323. This is not applicable to that Karnataka Municipal Administrative Service. Yes.
I am right.
Yes, that's.
Then
Yes. I put volume.
Not been amended there.
Yes. Yes. Yes.
Establishment of Karnataka Municipal Service.
Yes.
As the appointed team, there shall be a Karnataka Municipal Service for the state of Karnataka. Of the categories of posts as specified in column 2 of the one.
Yes.
The number of posts of each category in the scale of preferred post shall be specified in the corresponding entries in column 3 and 4. Right? Schedule 1 में कहीं नहीं.
Yes.
Municipal Commission grade 1.
Yes.
Number of posts specified only P.
Yes.
And it has amended once because the reference one bottom number B.
Yes.
Last two the one. So one. Earlier it was 4, then it is reduced to 3.
Yes.
Then the 2 municipal commission grade 2.
Yes.
Post 10. Earlier it was 8.
Yes.
So thereafter we got these are 1970. Thereafter it has not been amended. Submission was still for delivery of the regular itself says. Just point out. This paragraph 80.
Paragraph
80.
80.
Page 19.
Yes. Yes.
Such a paragraph, such employment, post under state, post under municipalities. The above definition leads to the officer of survey of municipality is a person employed in the administrative or executive or municipal capacity. But other than those four non-KMS,
Yes.
this also indicates that posts are under these respective municipalities. The distinction between these posts and posts, the nature of the then I'll take
Yes. Where are you reading? 40. Yes. Yes.
And subsequent not civic post in the state. They are post in municipalities. The position is the CM officer. It is CM officer. Community affairs officer. It's a post not under municipality.
No, there is no dispute.
Then I come. Municipal service or persons appointed as chief officer of civil service of the state or government service. This tribunal has restriction on section 51B of the Administrative Services Act. Both the matters relate to their service.
Yes.
With respect to other employees holding different posts in municipality, this has no restriction on their financial service. The fourth is important. This tribunal has no jurisdiction over the service matters of employees of municipality appointed as chief officer. They are not members of a municipality, cannot be promoted. He is not a of
This tribunal has no jurisdiction over the service matters of an employee of the municipalities appointed as a chief officer. No, that is what that from the day one I am asking you. You said the post they are holding has to be considered. I asked you if it is not if he is not a civil servant, but he has been posted to that civil post, what is the effect? You said that it is the post on that the first day itself I want that your assistant to see that not in this case. I've also asked you, if suppose if the employee, government employee has been deputed to that corporation, then you said that since he is holding that post of the corporation, it has to be before this court. I am asking that question. That is the main point. Not in this case. I want to know what is that, Mr. Satish. This is the point where if he is not a civil servant, but he has been posted to civil post, whether he has to approach the KAT or here, that is the point.
Suppose I'm a government servant.
Yes.
I'm on deputation to BBMP.
Yes.
BBMP repatriates my service.
Yes.
Question arose whether I have to approach, since I'm working in BBMP, whether I have to approach the High Court or the tribunal.
Yes.
The division bench of this one court in 1989 LR. I'm not aware of the page.
Yes.
Held that this court has got jurisdiction.
Because you are holding the post, which is.
Since he is holding the post, civil post.
But not the condition of your appointment and all. Then it is reverse, that is contrary. His full bench judgment of the KAT is contrary to what he is saying then.
Full bench of the tribunal, but in Sangappa real.
Yes.
But I have myself appeared.
Yes. Yes.
But the full bench of the tribunal has held that except KMS officer, but other officers, this court has got.
No. Other officer holding that civil post. See.
Holding civil. Yes.
Yes. See. He is a municipal officer. That this is the contrary what you are saying, that he is a municipal officer. He has been posted to commissioner. Commissioner is a civil post. Whether he has to approach the KAT or this thing, according to that division bench, you are saying that he has to approach civil court, because post which is disputed here, he is that post of that. It is not where he has been appointed, where he has been working. Now he is holding the post is that municipal commissioner. Municipal commissioner is a civil post. There is no dispute that. Then where he has to go? If see this is something different. But if that division bench said, then KAT order three bench judgment is not for this case. That day I asked Nagaraj for this only, because I have across so many cases. I have to see where they have to. No, that is no, Mr. No, let us see that. That is the dispute. Now that this point is already decided by some cases, therefore I want that assistance.
Criteria is if I am a holder of civil post, I have to approach the KAT.
Yes.
If I am not holder of civil post, I have to approach my lords.
Yeah. That is what that. But here, no. Therefore, you have appeared in that full bench. Then this is overruled by the division bench. Yeah. 89 agli or 70 agli. This is an high court. Yes. That is what now that, because why that we are entertaining that case of that officer who has deputation on that municipality, some corporation. Therefore, I asked you to verify that on that point. No, even that Satish has appeared so many cases. They are in a government employees. They have been deputed to the corporation, but all writ petitions has been filed before this court. Even though he is a government servant, the post now is dispute is that corporation. Therefore, I am asking to assist. I can send them also KAT. Yes, that's what. No, why Krishnappa? All that has come. There, it is not detailed order. Therefore, I asked the council to assist. If there is any detail, because it may be in further, there should not be any this thing until. But I asked that. Where is that division bench? No. Yes, let us see. That is all. I have not asked about this case. On that day, I hope that Nagaraj can assist this court regarding that point. But on that day, you have said.
I was knowing this judgment, but not lay my hands on this single judgment. I was knowing that it was something.
No. I think our High Court judgment, why you are going for the gate? High Court judgments are available. See, if you read that, what is the meaning of the service, civil service matter, the post there use the word. I want that to develop the arguments on that basis. But what you have said, you have interested on this, your client, and you have searched on this basis. Therefore, you have not get the correct judgment. Yes. No. Usually, advocates are going to search that judgment is in favor of their clients. That is not correct. No. This is the case. Simple transfer. See, I have seen that so many cases transfer in respect of that municipalities, where most of them are then this thing. What is your client? Is an community affairs officer. Writ petition has been entertained by this court, but in one cases it said that therefore you should not. No. That is not the issue now. Therefore, I said not only this cases in corporations matters also we are entertaining. Therefore, when you have appeared, I told you that you verify.
But I have.
Yes.
Is the post which is held by an officer
Has to
needs
be-
to be tested.
Yes. Then
Section
yes.
15 and 22 of the Administrative Act.
Yes, that is what that meaning of that services.
The question is answered. But I have. Who has passed the order is irrelevant.
No, that post which we are now deciding. That's
Post which I hold.
Yes.
If I am not holding a civil post,
Yes.
then not following this division bench of this one recently about 4 months back held that is the
post which is.
post of it. Not I have not relegated the matter to and not there is one more judgment.
Yes.
Jacob versus the state of Kerala.
Yes.
2004. Again, when I am not aware of
Yes.
this post has not been specified as a case.
That will consider. Yes. No, Mr. I will finish. Now that so many cases we have entertained that writ petition. See, I have spent lot of time for this.
Where is the specification to specify the post as a commissioner? Only 10 posts have been specified.
No, I will answer. I will see, Mr. It is not that rule for only 10 commissioner has been declared as an Karnataka municipal administration. That class under that scheduled 1, what are the designation has been given, that has been.
That is not applicable to the KMS officer, Lord.
No, Mr. As per that 1970 rules, they said they are creating this post under the Karnataka Municipal Administrative Service.
Yes.
Along with that, they said there are 10 posts has been. That doesn't mean that only a 10 persons has been declared. That post of that Commissioner of Municipal Grade 1 has been declared as an Karnataka Municipal Administrative Service.
Not then, Lord. 10 rules have no application.
Not 10, Mr. 70 has held. First post has been created under that 70 rules. 2010, what they did, category of the post has been, that can be done under C&R rule. C&R rules ali, instead of every time 10, 4, 16 extend madabadlo, they said TMC ke one municipal grade. That I will answer. Yes, I.
2010, Lord, nowhere applies to this.
No, it is not applicable to that, Mr. There, under that C&R rule, the post has been mentioned there. They are not creating that Karnataka Municipal Administrative Service. It has been created under 70. Cadre post ಎಷ್ಟು ಇರಬೇಕು ಅನ್ನೋದನ್ನ C&R ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು. Ultimately ವರ್ಷ ಎನ್ಹಾನ್ಸ್ ಮಾಡ್ಕೊಂಡು 20, 30 ಅನ್ನೋಕ್ಕಿಂತ then what they said under C&R rule, wherever there is a TMC, that one post has to be KMC, that is that created under that rule of 2010. I will answer that. Otherwise, therefore, yes, otherwise you are saying that every year that.
Then that will not, no officer, the other cadre can be appointed first.
No, that is the.
Even appointed,
not. No. Therefore, see, if it is notified, under 365, nobody can be appointed.
Yes.
If it is not notified, that post is that Karnataka Municipal Administrative, but government can appoint anybody because it is not notified under 365. If it is notified, then that is the distinction. Yes, yes.
365
Not redundant, Mr. 365, one sorry government wants that this TMC has to be notified on there. They cannot appoint anybody except that Karnataka Municipal Administrative Service. That power is there. But in your case, it is not notified. They can appoint you. Andre, yak notify madilla anta andre, since there is no such post, they have left it. They can appoint you. Now they have been appointed you. Now you are working as a commissioner. Since it is a civil post, you have to go to there. That is the district. Yes, your submission will be considered. I read, Mr. 365 is that is that. Yes, that's all. Right. No, my order, they can't say that full court judgment is there. Yes.
My lord's view is not endorsed. ST is not whether he is holding the post of civil post.
Yes.
Is a test.
Heard the learned counsel for the parties. Petitioner is a community affair officer by order dated 22/1/2020, Annexure A. He has been posted to Municipal Commissioner this is Chelkere. Yes. Municipal Commissioner Chelkere, grade 2 nado. Chelkere Municipal City Municipal Council, grade 2. The preliminary objection raised since the post which is held by the petitioner is a civil post, the writ petition is not maintainable. To decide that question, it is better to refer section 327 the appointment of the chief officer. Same has been extracted below. The municipal council has been defined. Section 2, subclass 4. Municipal council means the councils of town or city municipal area established under this act. By reading that above provision, it is very clear that every town or city municipal council shall have an officer who shall be appointed by the director of municipal administration from the person in the cadre of chief officer of Karnataka Municipal Administrative Service. Exception to this section 331 as read under. It is very clear from section 331, notwithstanding anything contained in section 327, the government may appoint as a municipal commissioner for any city municipal area. Section 365 of the Act reads that notwithstanding anything contained in this Act or any other law for the taming of the post, such post under every local authority as may be specified by the government shall be filled by appointment of officer belongs to Karnataka Municipal Administrative Service. The government, by exercising the power under Article 309 of Constitution of India, framed the rules called the Karnataka Municipal Administrative Service Rules 1970. As per Rule 3, there shall be a Karnataka Municipal Administrative Service for the state of Karnataka, consisting of category of the post as specified in column number 2 of Schedule 1. Under Schedule 1, column number 2, the category of the posts are Municipal Commissioner Grade 1, Municipal Commissioner Grade 2, Chief Officer Grade 1, Chief Officer Grade 2, Chief Officer Grade 4, and Chief Officer Grade 3 and Grade 4. Yes, Karnataka Municipal Office Grade 1, Grade 2, Chief Officer Grade 1 and Grade 2. Yes. Yes. The post which petitioners now held is Karnataka. Adadmele 2010 rules. The government, by exercising the power under Section 323, subclass 2G of Karnataka Municipalities Act, has framed the rules called Karnataka Municipalities (L) Recruitment of Officers and Employees Rules 2010. As per the rules, Schedule 1, the cadre strength allocated to the different category of the urban local bodies as mentioned. As per that rules, grade 1 CMC has one post of municipal commissioner grade 1. Grade 2 CMC has municipal commissioner grade 2. The post which is held by the petitioner is a city municipal council grade 2. City municipal post of the municipal commissioner grade 2. Since the post held by the petitioner is a civil post under Karnataka Municipal Administrative Service, the petitioner has to approach Karnataka Administrative Tribunal. This court which is that relevant to held that it's a post instead of referring all this. Alala, that's Mumbala is the right judgment or another one we have referred.
Samindra Das. 2004 to
Pass an order of 15% government holding the speed portion. This court in ILR 1989, Karnataka 816 has held that if the government servant holding the civil post under the government, he has to move tribunal for relief. The post which the officer is hold is the test to be determined whether he is holding the civil post or not. Administrative tribunal. Chandra Kumar judgment. Subsection class 2, subclass Q as defined the service matter. Yes. Chain has been extracted below. Section 15 is related to jurisdiction and power and authority of the state administrative tribunal. By reading that above provision, it is very clear that all service matter concerning a person pertain to the service in connections with affairs of the state, he has to approach Karnataka Administrative Tribunal. It is that provision which is barred under 28. Section 28 of the Act has excludes the jurisdiction of the court except the Supreme Court under Article 136 of Constitution of India. This has been considered by the apex court in L. Chandrakumar case. The main case is also the Supreme Court on judgment L. Chandrakumar. Yes. Apex Court, in case of L. Chandrakumar and Union of India, 1997-3, SEC 261, Paragraph 99. 98 and 99 is struck. In view of the above, since the petitioner is holding the civil post of commissioner grade 2, his petition filed under 226 Constitution of India before this court is not maintainable, reserving liberty to the petitioner to approach Karnataka Administrative Tribunal. The petition is dismissed. Facts dictation ಕೊಟ್ಟಿದ್ದೀವಿ ಕಾಪಿ ಅದೇ ಕೊಟ್ರಲ್ಲ ಅಲ್ಲಿ.
Serial number 47, Vasant Kumar HP for petitioner, Sujata BA.
Yes. Yes. What is that mandamus you sought? Yes. Yes. 1998. Yes. Yes. Yes.
To provide the protected site in review of the revenue site.
Yes.
Which is running the demon.
Yes.
They also got demon protected site.
Yes.
Protected site and allotment letter will be issued on 26/4/2019, which is the current section 828.
Yes.
So after issuing the allotment letter,
Yes.
the endorsement came to be issued, calling upon the petition to pay the stated value of 11,37,000.
Yes.
9/4/2021, which is the demon.
Yes.
So after issuing the endorsement,
Yes.
within the period of 2 days, the entire setup has to be paid by the petitioner.
Yes. Yes.
Now, after accepting the interest amount,
Yes.
most of it has to be executed. It is a retired police officer, it's a retired GSI has been acquired to the party.
When you have paid that amount?
11,37,000.
ಮತ್ತು ಪಾವತಿಸಿದ ಚಲನ್ ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಬೇಕಾಗಿ ಈ ಮೂಲಕ they have demanded 9/4/2021. Annexure D is 9/4/2021. Yes. Yes, Mr. Yes. Yes. Now that you have you approached that authority? Yes.
The survey number.
No, we are not concerned. I'm not deciding that suit here. You have seen that sale deed. Before allotment, you have to see that. Whether is a owner there, the authority is there to see all this and pass an order. There you are sitting this, AC chamber, pass in a resolution, allot the land, ask to pay that amount. Then you will allot that land to somebody else. Then creating that. Why can't you see when you have passed in a resolution whether he is a owner or not? That do you think that BDA resolution has no value? When you are passing in a value, you have passed in a resolution. You should have applied mind. See that whether he is owner or not. If somebody given a representation, you will pass in a resolution, allot it, ask them to pay that amount. When he asked for an executing the sale deed, there is no site. How can you execute? That is the problem creating the BDM. Now you don't ask me to see that why you have asked him to pay that amount, why you have allotted. Then even after realizing you are not cancelling also, you just keeping allotting somebody other's person. Yes, yes. Now what has happened now? Why you are? Yes. That is not oversight, mister. It is not one case. Whoever approached the BDA, they will pass a resolution. I don't know why that all power has been given to that BDA. Pass a resolution, ಹಕ್ಕುಪತ್ರ ಒಂದು printed ಅಂತ ಮಾಮೂಲಿ ಇದೆ ಹೆಸರು ಬರ್ದು fill up ಮಾಡ್ಬಿಟ್ಟು give it, pay that amount. Now that after that only everything will stop, then we have to scrutiny everything and pass an order. This is how that BDA is doing. See, on 9/4/2021, recently you have asked them to demand that money. How can that he ask? How that resolution has been passed? Nobody will question you doing that all resolution and all. This is be headed by that chairman, and then commissioner is also in this thing. It's a part of that resolution. Why they are not passing any, seeing any records passing the resolution? This is how that some of them very innocent. They are lifelong. They have to be fighting for this site throughout life. They will not get it. If the beginning itself, if you are rejected, you are not an owner. You might have been approached somewhere else. Yes. Now that this is the problem, mister. Now we can't do all these things. What to do now? Where is your representation pursuant to that, mister? You consider, you pass an order, whatever you want. If you are, now that he has given an option for you, now you can say that no, you can be cancelled or whatever you want, you do it. Yes. That cannot be. Now you can't say that he is not a owner. You say it in his endorsement. Yes. This writ petition, petitioner has sought following relief. The facts of the case are that the petitioner is the owner of the revenue site bearing number 7, found in survey number 27/2, measuring 30 into 40, situated at Ramasandra village, Yashwantpura Hobali, Bangalore North Taluk. That has been acquired. Said land has been acquired by the BDA after issuing preliminary and final notification. This allotment of the site has been made under that scheme. Is it not? Junjama.
So allot the alternative site in your private sector who have executed the sale prior to the
No, there. Yes. Pursuant to that, in view of judgment of this court, in case of Junjama and others versus Bangalore Development Authority, ILR 2005, Karnataka 608, the petitioner has approached the respondent for allotment of site. Considering the request of the petitioner, the BDA has passed a resolution as per Annexure B for allotment of site measuring 30 into 40 in favor of the petitioner. Pursuant to that resolution, respondent has issued Akupatra on 26/4/2019. Allotment letter on 24/6/2019. This all shows how you are doing. 2007 resolution. ಅದೆಲ್ಲ ತೆಗೆದುಬಿಟ್ಟು ಈಗ ಯಾರೋ ಆಫೀಸರ್ ಹುಡುಕ್ಬಿಟ್ಟು ಇಲ್ಲೊಂದು ರೆಸೊಲ್ಯೂಷನ್ ಇದೆ ಬನ್ನಿ ನಿಮಗೆ ಒಂದು ಹಕ್ಕುಪತ್ರ ಕೊಡ್ತೀನಿ ಅಂತ ಕೊಡೋದು. ಇಲ್ಲ ಅಂದ್ರೆ 2007 ಅಲ್ಲಿ ಆಗಿರೋ ರೆಸೊಲ್ಯೂಷನ್ ಅಲ್ಲಿ 19ವರೆಗೂ ಇಲ್ಲ. 19ರಲ್ಲಿ ಯಾರೋ ಒಬ್ರು ಬಂದ್ಬಿಟ್ಟು ಪುಣ್ಯಾತ್ಮರು ಹಕ್ಕುಪತ್ರ ಕೊಟ್ಬಿಡ್ತಾರೆ. ದಿಸ್ ಇಸ್ ಹೌ ದಟ್. Issued on 26/4/2019 and demanded What is that price? Allotment price? ಏನಂತೀರಾ? What that amount called? No. Is it issued an hakupatra with a condition that petitioner has to pay 15,98,400 as the site value. ಅದು ದುಡ್ಡು ಕಟ್ಟಿದ್ರಾ ನೀವು? Remaining, pursuant to that, the BDA has demanded the petitioner to pay advance of rupees 11,37,000. Pursuant to that, endorsement dated 9/4/2021. As per the directions of the BDA, the petitioner has paid 11,37,000. The challan has been produced as Annexure E. Thereafter, the respondent has not executed the absolute sale deed. The petitioner has approached the respondent BDA with Annexure F dated by representation dated 14/7/2021. Since their representation is not considered, the petitioner is before this court. Shri Vasant Kumar, Learned Counsel, appearing for the petitioner, has submitted that after considering the request of the petitioner, Bangalore Development Authority has passed a resolution allotted the site in favor of the petitioner by allotment letter dated 26/4/2019, Annexure C. Thereafter, they have demanded they have issued an endorsement requesting the petitioner to deposit 11,37,000. Pursuant to their demand, the petitioner has paid that 11,37,000 as per challan Annexure E. In spite of that, the BDA has not executed the sale deed. Hence, he sought for allowing the writ petition. So and so Learned Counsel, appearing for the petitioner, respondent has submitted that since the vendor of the petitioner has received entire compensation, therefore the petitioner is not entitled for allotment of site. Or the Learned Counsel for the parties. Feroz, with papers. Be that as it may, the BDA has passed on a resolution to allot site in favor of the petitioner. Pursuant to that, has issued an allotment letter on 26/4/2019 with Annexure C for sum of rupees 15,98,700. As per the request of the BDA, the petitioner has paid 11,37,000 and he has submitted a representation for execution of absolute sale deed. The representation dated 14/7/2021 has been produced as Annexure F. So far, respondent has not considered that representation. Under these circumstances, it is suffice for this court to direct the respondent to consider that representation of the petitioner in accordance with law, not later than 3 months from the date of receipt of the copy of this order. It is made clear that this court has not expressed any opinion on the merit of the case. At least now we will verify who is that, whether he is a genuine owner or what. Yes.
48 attest, number 49, VP Sitaramaya for petitioner.
Yes.
Appearing for petitioner.
Yes.
My lord, petitioner's land has been acquired for Hemavati project.
Yes.
Petitioner has filed an application for reference under section 18 of the LA Act.
Yes.
That according to the SLAO, as per Annexure B,
Yes.
a list was prepared and matter was referred to civil court.
Oh, yes, this
Page
is the
number
matter.
10, Annexure B.
Now, see. Yes. No, otherwise, now we can't ask him to do it because there is a limitation for 18 reference. Yes. You yourself has referred. There is a reference is there, but it may be misplaced in the civil court, but he is not responsible. For that, you can't deny. Either you have to search out that and refer to that civil court, or that you have to build up in a file and refer it. Otherwise, yes. No, with that reference of that earlier number, now we can refer it. You ask that. Yes, 21. They are not denying that this is the order passed. Yes. Then they have to work out some remedy for him. Yes. Maybe he has sent it to a large number of that. It may be misplaced in the civil court. But you find out if you find these records is good. Otherwise, you have to build up and do it. That yes. 21. Let's release this matter on 24th.
Yes, please.
Number 50, S.A. Shivram for petitioner, Somashekar K. Prajwal P.
Yes. 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 Now, can he be transferred the one place to another? Yes. Then where is Shuram? Yes, next week. Yes. Release this matter next week.
Number 51, Satish K. for petitioner, connected matter, CL Sanjeev.
Yes, Mr. Sanjeev.
Milord.
Yes. He is also working as a chief engineer.
I am sorry, Milord. He is working in charge only.
My order has been recalled, Mr. because of your submission.
I'm extremely sorry, Milord. I was not because the objections objection ಹಾಕಿದಾಗಲೂ ನನಗೆ ಇದಿರಲಿಲ್ಲ ಬಟ್ ಆಮೇಲೆ ಗೊತ್ತಾಯ್ತು ನನಗೆ ಇನ್ಚಾರ್ಜ್ ಐ ಆಮ್ ಎಕ್ಸ್ಟ್ರೀಮ್ಲಿ ಸಾರಿ ಮೇಡಮ್ ದಿ ಸೇಮ್ ಆರ್ಡರ್
Same order. Accordingly, yes.
Only thing, my lord, they cannot take it as a right in charge.
Yes. ಅದಯ್ಯ ಪೋಸ್ಟ್ ಆಗಿಲ್ವಾ ವೆಕೇಟಿಂಗ್ ಮನೆ ಅವ್ರಿಗೆ ಫೈಲ್ ಮಾಡಲ್ಲ ಕೋರ್ಟಲ್ಲಿ
ಫೈಲ್ ಮಾಡಿದ್ವಿ
ನಂಬರ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ವಿ ಅದೇ ನಂಬರ್ ಕೊಡಿ IAS disposed of IA2 of 22 is this. Are they same in terms of? Yes.
I'm extremely sorry.
Yes.
Number 52, yeah, Vindraj for petitioner, Chanegowda.
Yes. Yes, we have disposed of. Yes. Yes. In terms of that, we'll dispose of. I have not given any positive direction. In fact, he has referred the judgment. There it is a positive direction. But I have said that you consider in accordance with terms of this disposal. Only that survey number will change. Now that you are not there, then the senior counsel was there. And senior counsel was made. Then we will have it on Tuesday instead of next week. Therefore, he is ready. He was there. We waited for some time. Then you are not there. Tomorrow, I don't think it will reach. Tomorrow, there is a reference and all. Tuesday. Monday, the service matter day. I don't think. Yes, we'll hear that. What is that? The government advocate also get an instruction that he is a temporary employee. Can that he has been transferred or not? That is the question. You have to say whether that transfer can be temporary employee, can be transferred. Yes, who has passed this transfer order? Then you have to say, madam. Why? No, not public interest. Simply making a litigation. Both the parties has to be approached the council. Tuesday. Yes. Yes, you ask them to. Yes. Withdraw it. It's well and good. Yes.
Final hearing matter.
Tuesday. Yes.
Cell number 53 adjourned.
Yes.
Cell number 53 adjourned. Cell number 54. RS Agre for petitioner.
Yes. 54.
RS Agre.
In 54, I beg to appear for the proposed impleading applicants.
Yes, where is that Hegde? Next week. Yes. 2002. Nobody is interested. No, that shows if the petitioner has no interest, then the advocates are not appearing.
My lords, may I make one small submission, my lords?
No, you are appearing for the petitioner.
I am appearing for the proposed applicants, my lords.
And so far,
your lordships,
nobody's interest has been affected now.
My lords, I have moved the matter, my lords, as a matter of fact, and I have time and again tried to reach out to the petitioners in the 2002 writ petition, my lords, but to no avail, my lords. They were represented earlier by Kesri and company, my lords. On the last occasion, they appeared, and they even made a submission that they would file an application for impleadment, my lords. Interestingly, that application has been filed, but subsequently a memo for retirement has also been moved by them, my lords. But my lords, if I may just make this one small submission, as a matter of fact, nothing survives for consideration at all, my lords, in this.
Not that your friend also made a submission.
Yes, my lords.
That has to be accepted by the petitioner council. That's all.
But my lords, may have just pointed out in just 1 minute, your lordships. May just give me a minute, not longer than that.
That is true, Mr. If the council is not there, what is the use in hearing and wasting the time? That's what I am thinking. If he is there, I am ready to hear.
I bow down, my lords. I bow down. But the difficulty is, my lords, it appears that they may never.
Whether they are prosecuting this case. The request of petitioner released this offer. Yes, where is Yagde? What to do, mister? Even if it is dismissed for default, tomorrow they will file an application for recall.
My lords, may I just point, my lords, even if court notice has to be sent out in writ petition number 32641 of 2002, your lordships will notice that even in the cause title, the address which has been given, my lords, it's an address which cannot be made out, my lords. They say resident of Kodiyali village, Yalanka. But tracing them will be a difficulty, your lordships.
Yes. When that matter has been heard sometime, there is a length. What is this? Yes. Yes. Yeah. Now they have come. This. Now members are challenging what?
No, the owners have challenged the petition.
Yes.
Yes. Challenge that order, saying that because we have been awarded with the site,
yes,
without hearing us that acquisition is satisfied.
Yes.
So the coordinate bench has allowed that petition and directed the landowners to increase the member in the petition and petition will be heard on merit. So that is how
no, in first. Therefore it's a 2000. Earlier writ petition has been allowed.
Yes.
Then it has been challenged by the impleading applicants.
Yes, my lord.
Then it has been sent it back.
It has, yes, my lord. It has been reopened.
It's like a review.
Milord, may I submit, Milord?
Yes, yes.
My lord, I am for the impleading applicant.
Yes.
There is the direction to file a copy of the order, which I have done. I have complied with the office objection.
Yes, yes.
Now
it is.
there are certain issues, my lord, which have to be decided as per WP 29555 to 570/10, my lord.
Yes.
It has been directed that the issues in that case had to be decided in this case.
Yes.
I have produced a copy of the order also.
Yes,
Therefore,
it
this
is
case,
available here. Now the
we are
problem
the
is that
interested party.
opponent is not there.
That's true, my lord. What our writ is connected to this, and the issues in that case has to be decided.
Where is that your repetition? Is there any?
WP 29555 of 10, my lord. It should be there.
That has been.
That has been disposed with the direction that the petitioners there have to be made respondents in this case.
Yes,
And
yes.
all the issues in that case have to be decided in this case, my lord.
Order so restored. Yes. This is the writ petition filed by that beneficiary.
Yes. Site
For
owner.
reviewing
Site
of
owner.
that order.
My lord, I will file a copy of the writ petition.
It is there, madam.
Your lordships, on the last occasion, I have
Now ultimately,
yes,
that earlier order has gone. Now that 2002 writ petition has to be heard afresh.
Yes, yes, my lord. Yes.
After hearing it, that applicants also.
Yes,
Now that is.
yes, my lord.
Yes. Where is that then? Hegde? Yes, we will grant one more time, Mr. What to do?
My impleading application may be allowed, my lord.
That we can do. Where is that application? That is
in-
also not considered.
No, my lord. It has to
AFR
be allowed in this case now.
Why that 2021? Now that the division bench has passed single judge. 2020 that writ petition has been allowed. Is it not?
It has been disposed with the direction, my lord, that the petitioners in that case have to be arrayed as respondents in this case. And
Since
all
they have
the
not made you yourself as, then they have failed to comply the direction.
exactly, my lord. That is why I have filed the impleading application.
Yes. IA 1 of 2021 is filed for the proposed respondent as respondent number ಎಷ್ಟು ಬರ್ತಾರೆ ಅವರು impleading applicant
6, my lord. 6.
including applicants
6 ಆಗುತ್ತೆ.
Mr. But you have also filed an application.
No, your lordships, I have not, because on the last occasion, my lords, when the matter had come up, there was a representative from Caseway and Company who undertook to file an impleadment application, my lords, on behalf of the petitioners. I was
don't wait for that. See, your colleague has, your colleague has filed an application.
Yes, my lord. I was under the impression it was filed by Caseway and Company, my lords. In that event, I'll prepare an application and I will also file it once.
Yes, at least our stage one mugili. IA 1 of 2021 is filed by impleading applicants. They are the beneficiary under the acquisition. This code in an earlier round of litigation, the above writ petition has been allowed. Being agreed by the same, the impleading applicants has filed a writ petition in WP number 2955-29570 of 2010, seeking recalling of that order passed by this court in WP number 32641 of 2002 dated. What order ಆಗಿದೆ?
6/7/2009.
6/7/2019.
2009 below.
19 ಅಂತ ಆಗಿದೆ ಆರ್ಡರ್ ಅಲ್ಲಿ.
My lords, that's a typographical error.
Correct ಆಗಿದೆ.
In the last
ಆಮೇಲೆ amend ಮಾಡಿದ್ದಾರೆ.
typographical error.
2009. This code. Yes. Has allowed the writ petition being agreed by the same. The impleading applicants has filed a writ petition before this court on so and so 2955-29570 of 2010 seeking recalling of the order passed by this court in WP number 32641 of 2010 disposed of on 6/7/2009. This court by order dated 25th July 2019 has allowed that writ petition and directed the petitioner herein to implead the impleading petitioners in WP number 2955-295710 as a party respondent. Since no application has been filed to implead, the applicant himself has filed this application for impleading. In view of order passed by this court in WP number 2955-2957
570 Milo.
10.
570 Milo.
Yes. The application is allowed. The impleading applicants is permitted to come on record as respondent number
6 and 7.
6 and 7. The petitioner is directed to amend the cost entry.
My lordships, may I also crave liberty to file another impediment application, my lords, for the proposed impediment.
File as like your colleague has filed in terms of that order, I will allow your application also.
Please,
I
my
have
lords.
because there is a direction. Yes.
Yes, my lords. Please, my lords, I will do.
It cannot be decided. Yes.
Grateful, my lords.
Cell number 55 adjourned. Cell number 56 B. Ramesh, Rajesh Patil for petitioner Saravana S.
Yes. What pass or no? Yes. At the request of the petitioner, release this matter next week. Yes. Next Wednesday. Yes.
Number 57 Sanket M. Energy for petitioner.
Yes.
Matter Sumana Naganand.
Yes. Yes. Senior counsel ilva. You are appearing for? Yes. Sumana Naganand. No, last time matter was not reached. Last week, last Friday, and some other matter was there. Then senior counsel was also present on that day. Then it has been urgent today. What to do? Tuesday. Release this matter on Tuesday.
Cell number 58 RBS Reddy for petitioner L. Srinivasa Babu.
Lords, I appear on behalf of the respondent number 5.
Yes.
I represent respondent number 4, my lord.
Yes.
In this case, I am for the petitioner, my lord.
Yes. Yes. Government has to say what. Yes.
Yes, my lord.
Yes. No, their ground is that they have not implemented that scheme. Then you place it on record. No, you place it giving the copy to the respondent petitioner. They have to know they are under the impression that you are not implemented. You file it. Yes, Mr. They are ready to file an objection. Let them file an objection.
My lord, one submission, my lord.
Yes. Yes, Mr.
Though as per the act has clearly stated that the after lapse of 5 years, my lord, though the award was not deposited, though that
Mr.
almost on 8 years land was acquired, my lord.
Now they are coming with that objection saying that award has been passed, scheme has been implemented.
No, then
Lord,
okay,
sir.
my lord, let them serve the copy, my lord. I will.
Yes. Yes. Now that question is, if it is deposited in that treasury, civil court. Yes. Yes, they have deposited in the civil. Let them file an objection. Let us see. What is the now that yes, if it is deposited in the civil court, I don't think Supreme Court judgment will come in your this. Yes. Yes, at the request of government advocate. Finally, 2 weeks time is granted to file an objection. Yes.
Grateful.
Serial number 659, M. Shiva Prakash for petitioner, connected matter.
Yes.
My lord, I appear for respondent number 3.
Appearing to the respondent number 7 in the connected matter, my lords.
ಅವ್ರು ಯಾವ್ದೋ ಯಾವ್ದಾವ್ದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರೋದು ಯಾವ್ದು ಯಾವ್ದು 59.1 ಏನಿದು ಇವು ಬಾಕಿತ್ತು ಯಾಕೆ why that has been clubbed? Same question of law is different. Now that ಯಾಕೆಂದ್ರೆ ಅದನ್ನ ನೀವು ಕೆಲವರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗಿ ಸ್ಟೇಟಸ್ ಗೆ ತಗೊಂಡಿದ್ರು ಅದನ್ನ ಇದ್ರ ಜೊತೆ ಕ್ಲಬ್ ಮಾಡಿ. Now that your case will be dealing, this is Rajiv Gandhi 59.15. 59.15 WP number 18066 of 2016 deals this matter on 15th. Rajesh matter.
59.16 may also be dealing.
Yes, 59.16. 59.16 is related to what? This is also wrong.
The prayer is for a declaration that the acquisition has lapsed under section 24(2). The acquisition is under KID Act.
Yes. Not. That is, now we will bifurcate some of that approach that Supreme Court and obtain the stay.
In this, there is no such stay, my lord.
This 59.6, I don't think so.
No,
some of the matter.
59.16.
59.16.
16.
Yes, who is appearing for that? Nishan. Yes. That our Supreme Court now first will dealing that cases where which is pending before the Supreme Court.
ಹೌದು ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ.
ಯಾವುದು ನಿಮ್ದು 16?
ಹೌದೌದು 59.16.
Is it applied
for the respondent in that?
Yes. Is it Mr. Chandrasekhar? This is also for Rajiv Gandhi University.
ಅದು ನೈಸ್ಗೆ BMICP.
BMICP.
ಹೌದು.
59.9, 59.11.
Where is that? ಅಲ್ಲ ಅವರೆಲ್ಲ ಆರ್ಡರ್ ಕೊಟ್ರಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೊಡಿ ಆಫೀಸ್ ನೋಡಿ ನಮ್ ಕೈಯಲ್ಲಿ ಕೊಟ್ಟು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ನಾವೇ ಸರ್ಚ್ ಮಾಡ್ಕೋಬೇಕು ಈಗ ಇದು ಯಾವ್ದಕ್ಕೆ ರೈಸ್ ಆಗುತ್ತೆ ವೇರ್ ಇಸ್ ಈ ಮಿಸ್ಟರ್ ಐ ಥಿಂಕ್ ಆಲ್ ರಾಜೇಶ್ ಮ್ಯಾಟರ್ಸ್
No, my lord.
Rajeshwar.
My lords, I appear on behalf of Mr. Rajeshwar.
Madam, which is the matters you have obtained stay in that?
My lords, it is serial number 59.14, my lords.
One by one. 59.9.
59.14, my lords. 58807 of 50.
The writ petition WP 58807 of 2015 is dealing from the WP number so first matter post this matter after 4 weeks. ಇನ್ಯಾವುದು ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್
ಅಷ್ಟೇ ಸ್ವಾಮಿ
ಅದು ಒಂದೇ
ಬಂದೆ
what about the other cases of
what
Rajesh?
was happen in writ appeal? There is a common order was came to be passed, my mind, all the matters.
Yes,
that was challenged before the SLP, my lord.
Yes, in the SLP they have obtained that interim order. Now they
There
have
are
produced
some more SLP have been filed, my lord. However, we have filed caveat. They have not yet served the copy.
No, that is what that council has to come before the court and say,
Please,
yes, we have filed an SLP or obtained the stay.
Please.
There, nobody is coming. Who is appearing for that other matters? But you are there, Mr.
59.16, my lord.
Yes.
59.16.
59.16. Yes, Mr. Nishant.
Lords, I appear for petitioner, my lords.
Yes. You are not approached the Supreme Court.
No, my lords.
Then all that cases which is not approached, then it is covered by decision. We have passed some order.
I'll seek instructions, my lords. Senior is not available today.
No, instruction has to be given by the party.
Yes, my lords.
Because he has to say, I have approached the Supreme Court or not. Is it not?
Yes, my lords. I will seek instructions from my senior, my lords.
Yes.
This matter is going on. There is an interim order in this.
Yes, and that is what now we are bifurcating.
Very well. That should be bifurcated. Yes.
Yes, we are not approached the Supreme Court. All that matter will be clubbed. One or more matter dismissed.
Very well.
Yes. ಈಗ ಅವರು ರಾಜೇಶ್ ಮ್ಯಾಟರ್ ಒಂದು ಇವ್ರದ್ದು ಒಂದು ಎರಡು. In nobody is present. In all other matters, we'll post on one day.
Very well. Monday.
Supreme Court has granted status for what?
Status quo.
Why that KDB has not filed any caveat before the Supreme Court?
Lord, we have filed caveat, my lord.
No, but in some cases, Supreme Court has later judgment said that it is not applicable. But they have obtained that interim order is also obtained that. Why you are not represented there?
We are represented through Advocate General, my lord.
No, not here, Mister. I'm asking that.
In Supreme Court also we have engaged service of the Advocate General, my lord.
Because if Supreme Court has concluded, then there is no other option. We can club all the matters together and pass an order.
Please, my lord.
The matter again, if it is pending before the Supreme Court means, then we can't pass any order. All other matters are Supreme Court dealing ಮಾಡಿದ್ಬಿಟ್ಟು post this matter. ಮತ್ತೆ ಯಾವ್ದೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ದುಡ್ಡು ಕೊಡ್ಬೋದು ಅಂತ. No, that if ಅಲ್ಲ ಯಾವ್ದೋ ಒಂದರಲ್ಲಿ notification has been issued after that new act came into the force. ಅಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ ಹೇಳಿಲ್ವಾ ಅಂತ. No, now I am asking whether Supreme Court has decided this point. No, if the acquisition, no, suppose today you have issued a notification for acquisition on KDB Act. Whether you have to pay the compensation under 2013 Act, this has been discussed. That is true. ಅಲ್ಲ ಬಟ್ ಇಲ್ಲಿ ಯಾವ್ದೋ ಒಂದ್ರಲ್ಲಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಯಾರು ಹೇಳಿ. ಬಟ್ ದಟ್ KDB has challenged that. ಅಲ್ಲ ಅದು ಸರಿ, ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಹೋಗಿರೋದು 24/2 ಮೇಲೆ. ಅಲ್ಲ ಹಂಗಾರೆ ಇದು ಯಾರು ಹೇಳಿದ್ರು ಅದು ಹಂಗಾರೆ ಕರೆಕ್ಟ್ ಅಲ್ಲ. Somebody said if acquisition notification has been issued after the 2013 Act came into the force, you have to pay the compensation in terms. There is no law has been declared.
My understanding is
yes,
KDB has passed a resolution
Then yes.
Came into force if any notification is being issued by the KEDP for acquisition, they will have to pay the compensation under the new act. That is a resolution, judgment.
Yes. No, but all these cases that is not applicable because this is all
No.
before.
This is all prior to the new act coming into force.
Yes. Onto bias case, yes. Yes, this is for BDA Act that. Yes. Yes. Regarding the opposite victims, when the subsequent act incorporates provisions of and independent factors subsequent unaffected by any repeal of the amendment violation. This principle, however, will not apply in the following cases. And the previous acts are supplemented to each other. Acts are very material. Yes. Yes, Mr. Naik did have it on 18th.
Very well.
All that matters. Who is that petitioners? Any other? Mr. Nishant?
Sir, kindly have this matter on 24th, my lord. There is one other matter on the same day which senior counsel appear on the same day.
24th, is it, Mr. Naik?
Very well, my lord. I have no objection.
24th. See, last week I have disposed of. So
please, my lord, where we are appeared in that matter.
Yes. Patil is appearing.
Please, my lord.
The terms you will dispose. If we are challenging it and obtain the stay order in the Supreme Court, it's well and good. Otherwise, we have to follow the division bench judgment.
Please, my lord.
Prakash. Yes. Other matters post on 24th.
Yes.
Very well, my lord.
One matter 15th. One after 4 weeks Supreme Court pending. Other matters all on 24th.
Yes. There is an interim order, my lords, which may be extended.
Yes, interim order. Sir, Nodi. Interim order granted earlier is extended next week. Common matter. Yes.
Yes. Number 60.
Yes. Yes, Mr. Chila. Yes. Yes. It is a state acquisition. Yes. Yes. No, it state has to answer. Yes. Huh? Now, let me see what is that. Yes. Again, in spite of that, the state yes. Yes. Yes, on question of law, we need not. Yes. So if the land is acquired for X purpose, it can use for Y purpose because that is a old land is yes. Now in this case, there are 3 grounds in acquisition you have to go. 1. Yes. If under declaration under section 6 is not issued, yes. 1 year. No, madam, this is land acquisition matter. It is only question of law. No, there is no question of facts. If law is settled in all aspects, if it is fixed after 1 year also same thing. You prepare on the law. If it is chance of any interpretation or you make any submission, you do it, you will consider. Otherwise,
that is fairly covered by the judgment of this court as far as section 6 is concerned. Award is not passed within 2 years.
no, that's
Section 11A is
section. No, it need not be any.
The objections, the land acquisition officer says we have not had objections, we have consented for the acquisition. We have challenged that notification before this court. This court directed us to file objections. We filed objections pointing out that in fact our use of program. Problems of percolate and token fees are there. In fact, your lordship may kindly see the paper you can write it. For the convenience of the lordship, because all these are all the same.
Yes. No, he is on that one legal point. Now that no, it is your own legislation. It says award has to be passed within 2 years. Otherwise, it is lapsed. You have to place in a records without objection saying that award is passed or not. For that, 2015 matter is going on. This is no, all these KDP matters and all. These are all that matter has been pending on different aspects and all. 11A is there from that.
Court is in mute, my lord. We can't. Court is in mute.
It is muted.
Court is muted, my lord.
Yes. Yes.
My lord, I appear for the beneficiary ISRO in this matter.
Yes.
My lord, I will also argue, my lord, after the state has argued.
Muni Krishna.
Yes, my lord.
Now that you have written a letter, you don't want this property, is it not?
My lord, a letter was written, but it is not that we did not want the property. What we said was we are not ready for a consent acquisition on a higher rates. We have written to the state government saying we want the lands. My lord, in fact, the state government has the latest letter also. We want these lands.
Yes. They don't go for any consent acquisition. Let them acquire under that new act. Because earlier act, it is lapsed.
My lord, by submission. My lord, I'll bring to the notice of this court, my lord, it is not as what my learned friend says. Let him argue, my lord, I am ready. Anytime, any date, my lord, even tomorrow, I am ready.
No, right. See, it is all question of law. It need not be here for 2 or 3 days. Yes. Now, what are your ground? Your ground is 11A. Yes. Make the note, madam. Just answer that.
Central Act will apply if the final declaration is not made in 1 year. The final declaration will be section 6
Yes.
Number 2, that award is required to last within a period of 2 years.
Yes.
The award itself is not passed within the period of 2 years. In fact, the government, in fact, they tried to mandate the margin because they
Yes.
Supreme Court held that only when the government gives a permission under Section 11 of the Act, then that is the award which is legally made. Now, this award has been admittedly made after 2 years. It lapsed. The third thing, the land acquisition officer, they do not file objections. We file objections and appeal to court. There is no consideration of objections.
No, that I don't think.
Not come because if your worship consider those two that.
No, even if that argument say ultimately, then we can say that give an opportunity and pass a fresh award. That will again goes to that. Yes. No. Yes. Now, if you are arguing the 2 points and you sustain that point, then yes, you have to answer that. Only 2 points.
Notification that is 28/1/2010.
28/1/2010. Yes.
So it was issued under Section 4, 17 of the Land Acquisition Act.
Yes.
So for the project of 2020,
yes,
they invoke emergency clause in the year 2010.
Yes.
So we approach this one to court by filing writ petitions.
Yes.
And in those writ petitions, we are challenged saying that for 10 years of project, you cannot invoke Section 17.
Yes.
Like this court passed an interim order earlier, and this was of stating that please treat this as a notification under Section 4 of the Land Acquisition Act.
Yes.
So then we filed objections saying that.
No, as it treated as a court itself has made it, or
court itself has passed an order. Please treat this as a notification to Section 4. Here all the land agents will pass an order. Then we filed objections pointing out that this is fully developed or acting in place, and there is a converted land, therefore it is not.
No, now that.
Yes.
Which is the date of preliminary notification?
28/1/2010.
No, that is under the 17th they have issued.
Yes.
Subsequently, 4/1 has not issued. Now, can you take that advantage because of pendency of the case? It is 2010. Final notification has been issued subsequently.
Final notification, excluding the period of limitation, we have to issue within a period of 1 year. So 28/1/2010 is a notification.
Yes.
Correct. This honorable court granted an interim order on 17/3/2010.
17/3/2010. Yes.
Right. Then this honorable court disposed of the reputation.
Yes.
On 18/6/2010.
That means to say on 18/6/2010 is the date of the preliminary notification.
No, it relates back. So why you have to say explication to Section 6A? Right?
No, exclude.
No,
that is no. Here, different is notification is under 17. Invoke, yes, 4/1. No, that is true.
Yes.
Including 4/1 and 17, they have invoked, is it not?
That's right.
Under that circumstances,
yes,
that has to be treated as a 4/1.
Yes, that is what that all of the single judgment that is not challenged. Order which is at page.
Yes.
Page 164.
Award land acquisition act. Suppose if notification issued invoking emergency clause also,
yes, then
final notification is within 1 year. Same.
No, it's not within 1 year. It is beyond 1 year.
Alala. What is that section says?
Section 4
Subject to the provisions of the Act, appropriate government.
Yes.
Notification under section 4 irrespective of whether it is.
Kindly come to section 6.
Yes, 6.
Yes. Section 6. Subject to the provisions of Part 4 of the Act, when the appropriate government is satisfied after considering the report, if any, made under Section 5, subsection 2, that any particular land is needed for public purpose and for a company, the declaration shall be made to effect that under the signature of the secretary to such government or some officer duly authorized to certify the order, a different declaration is made from time to time with respect of different parcels of the land covered by some notification report, subsection 1, irrespective of whether one report or different.
Yes.
Kindly see that this is provided. Provided no declaration in respect of any particular land covered by a notification under section 4, subsection 1 shall be published after the commencement of the, this will not apply.
Yes, yes.
after the commencement of Land Acquisition Act, Ordinance 1967,
What is the
before the commencement of Land Acquisition Amendment Act 1984 shall be made after expiry of 3 years from the date of the publication. That is prior to 87.
Yes, yes.
Published after the commencement of Land Acquisition Act shall be made after the expiry of 1 year from the date of the publication of the notification.
Yes.
So therefore, provided further, no declaration shall be made unless the compensation to be awarded for such party is to be paid by a company or wholly party out of public revenues or some funds controlled by it. Then kind of explanation 1.
Yes.
In computing the period referred to for first provider, the period during which any action or proceeding taken in pursuance of the notification under section 4 of section is paid by the court shall be there.
No, now that, what is the consequence?
The consequence is that if whatever the period of the interim order granted.
No, that is true.
Yes.
If it is not within 1 year.
Yes. Section 6 declaration goes.
No, the section 6 says.
Yes.
Publishing after the commencement of the land expiring of the. Suppose.
Published after the amendment shall be, that means that there are 2 judgments of this court after 1984 amendment.
Yes.
Central Act prevails so. So therefore, after 1 year of the final preliminary notification, no final declaration can be made. Even if the final declaration is made non-ST in the eye of law.
Is it that any such judgment and declaring? That is what the see. It is not like that now new act that the acquisition is lapsed. There is no such word. They said it should be 1 year. Suppose if it is
this court has taken
consider that yes. Then that is the your first.
Here it says no declaration. This is what the language.
No, in spite of that, if they are issued a declaration,
yeah.
What
so
is
that
that?
becomes non-ST in the eye of law.
Yes.
Yes.
That is.
Yes.
Notification under preliminary notification is on.
Yes.
28.
28 1 2010.
Yes.
This was challenged to this court on 17/3/2010.
Yes.
The interim order was granted.
Yes.
18/6/2010, this honorable court disposed of vacated the interim order.
Yes. Where is the final?
There was 120 days. There was an interim order which was pending. Then the final declaration that is made on 35/2011.
35/2011.
Decided on 36/2011.
Yes. How many days delay?
It goes beyond 1 year.
Beyond 1 year.
You could see January to January.
Yes.
January to January, it's 1 year.
Yes.
And if your Russian could include 122 days.
Yes. No, January to January 1 year.
Yes.
After that, again there February, March, April, May, 4 months.
Yes.
Yes. 1 year, 4 months.
This is the date on which is gazetted.
Yes.
So paper publication is 35/2011.
Yes.
Now this is clearly barred under proviso to section 6(1).
Yes. 1. Second.
That is then yes. Then in regard to the second submissions, as
Yes.
a character, then I think
Yes.
the motion is not made.
Yes.
The land is done. In fact, we had till the filing of the writ petition.
Yes.
The award was not disclosed. We filed the writ petition to this court.
The page 130, 132 is that award notice.
Yes. Award was not even brought to notice. Even now it's not served on us. Under section 12(2), the moment award is passed, they are required to give us a notice under section 12(2).
No, even assuming that. Whether that award is passed within that 2
This
years.
is not possible. Award, in fact, if you file a statement of objection,
Yes.
your Russian kindly see. The final declaration, if your Russian date 35/2011,
Yes.
the government has granted the permission to pass an award on 19/7/2013.
2013.
13.
Hmm.
So that is as per judgment of Supreme Court in Rajiv Gupta's case. That should be taken as a date on which the award is approved. That is the date of the award.
Again, there is a short.
Yes.
Yes.
If the Russian date 35/2011, and there are 35/2012.
Yes.
It is on 19/7/2013. It's clearly drawn under section 11A.
Yes, madam. How to come over this legal hurdle? Is there any judgment on your favor? So that if it is a short delay, it can be over. Because there is only 2-3 months. There is no such, because it is in a legislative law.
There is no power to control the delay. That is a expropriate. Supreme Court cannot say it is all expropriate legislation.
It cannot
They
be.
have to be implemented strictly, and then following of this mandate strictly is the.
Yes, Mr. Unikrishnan, what is your answer for that?
The answer for everything, including the dates mentioned, are wrong. It is from the last of the declaration which award has to be passed. My lord, if this matter can be taken up on 16th for my argument with all the facts I will bring, my lord, including citations, which says that, my lord, that time fixed is 1 year, 2 years, etc. is not mandatory.
18th. Madam, he is not, he is a beneficiary.
17th.
That all records.
The state government has just different correct.
No, any.
And that's over a unique mission.
Now, whoever may be, this court is concerned, anybody can assist. Because if there is a good assistance, I can give a good judgment. Yes.
My lord, 17th, my lord, instead of 18th. 17th March.
Yes, 17th. Yes.
17th, my lord.
Land acquisition.
17th.
Yes. No, by these are all has to be shown by records only.
The letter written by them, several meetings ahead.
No, that is not. No, it is not your concern because you are attacking on these 2 points. Even whether written, they don't want all this immaterial. If this.
May I make a submission, my lord?
Yes, Mr. Reddy.
For the petitioner in WP 19287 of 90, along with the 2 grounds, I have one more ground in my particular case.
Yes.
I'm challenging this under section 5A also. Opportunity of being heard.
No, he is also on that ground.
No,
that is not more beneficiary for him. Even at least court can say go and opportunity and here, then they will pass an award.
No, my lord. It cannot.
This.
Yes, that's all. This section 6 parameters.
Now you give.
I will make one more compilation.
Now compilation, give that one judgment on that one proposition. It is enough. Yes. Because
there are a number of judgments where I have selected only 2 and 3.
Because
you are delivering my side 100 judgment.
Yes. See, law itself is clear.
Yes.
It is law itself says that it has to be within 1 year and 2 years. In addition to that,
the security colonies case has extensively dealt with sections of expropriate legislation. Strict compliance is required.
That judgment you
place.
Yes, you place that judgment.
Yes, I have.
Now that only that documents with the date, that is the only point which is involved. Yes, 17th. Yes, 17th. Yes, Mr. Unikrishnan.
Yes, I am ready. 17th.
Come on, physical hearing on that.
Physical. I'm sorry, my lord. Today.
Yes.
Number 61. For petitioner Sunita Srinivas.
Yes, Mr. What is this? Yes. Yes. Which department? Soaps and detergent. Yes. Yes. You have produced. Yes. 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 Yes.
senior officer. Thereafter, on 21/1/2015.
Yes.
Discharged.
Yes.
On the ground that at column number 17,
H.
I have not disclosed certain information regard to involvement of the petitioner in a criminal case.
No, see, you have been appointed as on a probationary basis or you are in a permanent appointment? Probationary. Yes.
Next, 8 page 22.
Yes.
Is the order of appointment.
Yes.
But I have been got 2 years probation.
Yes.
Within that, next B page 25.
Yes.
21/1/2015.
Yes.
I was relieved.
Yes.
Question next B.
Yes.
I approached this court.
Yes.
This court allowed the petition in part.
Yes.
And
On what ground the petition has been allowed?
on the ground that it is a stigmatic order. No inquiry is held.
Yes.
Therefore, liberty is reserved to hold an inquiry in the petitioner.
Yes.
May I request not kindly refer to page 31, para 7.
Yes.
Our removal order attached stigma to the petitioner. It states that he is removed from service because he has cheated the respondent company by not publishing the requisite information. As such an order, the necessary pre-requirement would be to hold the inquiry on the short ground of improved order being systematic and not being succeeded by holding an inquiry.
Yes. Yes.
The respondent is directed to hold and conclude the inquiry proceedings in 6 weeks' time.
Yes.
But thereafter, being statement is not automatic, is observation at para 8.
Yes.
The flashing of the improved order does not automatically entitle the petitioner to the relief of reinstatement. The petitioner has not even become a permanent employee. So the question of suspending him pending inquiry would not arise. His reputation is at risk in the sworn job.
Yes.
Cannot be directed to reinstate him pending inquiry. The reinstatement.
Yes. Yes. After that.
Thereafter, the annexed D page 32, pursuant to the decision direction issued by personal court, articles of charge were issued.
Yes.
But the sole charge is page 35. I have not disclosed not my involvement in a criminal case.
Yes.
If the charge which is held against me,
yes.
But I participated in the inquiry.
Yes.
But inquiry report is that next E. Come to page 50. 20.
Yes.
For the aforesaid reasons, I come to the conclusion that disciplinary authority has failed to prove the articles of charge leveled against D.O. Raju. The charge is not proved.
Page
50.
Yes. After report when you record there are forward
20.
Disciplinary authority has failed to prove the article. Yes. Inquiry officer has submitted a report.
Not proved.
Yes.
6/12/2016 is the report.
Yes.
That thereafter,
yes.
Next page 59. But this inquiry report was not rejected without assigning any reasons, and fresh inquiry is
yes.
ordered to be ordered.
Yes.
Page 59.
Yes, yes. Yes.
Challenging this order,
yes.
Order is dated 25/3/2016. I approached the Dissolve Court, which is at page 6.
Yes, yes.
But Dissolve Court allowed the repetition and quashed the order dated 25/3/2016, page 67.
That it is initiated of fresh inquiry against the petition, but strictly in accordance with law.
Page 67.
Yes, yes.
But I made a representation, reinstatement.
Now, on what ground it is set aside? Is it reason has to be required for inquiry? Fresh inquiry that under 14, 11. Yes. Reason has to be recorded by the disciplinary authority. Yes, I think yes, yes. Well, there on that. Yes. Yes, sir. Yes.
Petition 1439/2015. It says that
The reason has to be recorded. Yes. Yes. Yeah, that is the word I think distinguished. That will come to that provision later. Now, what has happened then after that? No, that is not the issue now. Now that has been.
It is not the issue.
Yes.
I'm just narrating.
Yes,
That
yes.
is not the issue.
Yes.
I consider that is not the issue.
Yes.
I made a representation. They rejected it. And Lord, for this fresh inquiry is held.
Yes.
Now, Lord, the fresh inquiry is Lord annexure K page 75.
Yes.
Imputation of charges page 81.
Yes. Yes.
There is the charge.
Yes.
This is the charge. ನೀವು ಬೆಳಗಿನ ಬೆಳಗ್ಗೆ ಒಳಗಾಗಿದ್ದೀರಾ ಯಾವುದೇ ತಪ್ಪಿನಿಂದ ಸೇವೆಯಿಂದ ವಜಾ ಆಗಿದ್ದೀರಾ ರದ್ದುಗೊಳಿಸಲಾಗಿದ್ದೀರಾ
No, same charges. I don't think just huh? You change the charge. Yes, yes. Yes, there is a different charge now. Yes. Yes. Yes, so please.
Can you take please certify the earlier charge?
No, what I want to know is it earlier you have initiated that, then inquiry officer has submitted a report saying that charges has not proved. I think there is a provision for 11A.
Action on the inquiry report.
Or that there has to be.
There are two options available. One is not for further inquiry.
Further inquiry.
Or not,
with even then there is a report of that, but disciplinary authority has a power to disagree and take any decision.
That is what my lords have held.
Yes, yes.
In fact,
That yes.
but the state of Karnataka versus
Varadaraj.
lords have
Yes, that is what that must be. Now, is it permissible for you to issue a fresh charges or fresh inquiry? No, because the charges itself is now different. Is it like any your inquiry?
There was an order from this honorable court to conduct fresh inquiry. It is at page number 57.
However, it is free to initiate a fresh departmental inquiry against the petitioner, but strictly in accordance with law.
It was not challenged by them, based on this, we gave the fresh.
Within the jurisdiction to appoint an inquiry officer, but before inquiry officer can appoint a fresh charges to be furnished. Now, if this court, Justice Chavan's judgment is allowed on the ground that you have not given any reason, you have to do fresh inquiry means you have to give that reason and continue, or you have to initiate first charge sheet and this thing. Yes. Page number 50. Yes.
The only contention was, at least charges was, convicted for any criminal or other offense.
Yes.
That was not true. Come to the new charges.
No, that is true.
Please.
New charges will come.
Please.
Whether is it permissible, Anta, that's what.
Court only has granted us the liberty to go ahead with the fresh inquiry with regard to the charges which we found later on after this charge.
Is it that tenor of the judgment? Judgment says, see, then you are without giving that reasoning, You have asked for a fresh inquiry. Therefore, it is set aside. It do it as afresh antandre, given a reason and continue. Or that you are taking that advantage saying that new charges and inquiry.
That was not issue before this on in this case. Question was without giving notice to him, without giving notice to the petitioner, directly he appointed the inquiry officer after that charges.
Yes.
After that charges, without giving fresh inquiry notice or notice to him, we directly appointed the inquiry officer. That order was challenged before this honorable court in this writ petition. That is 19505 of 2016.
Yes.
That the court held that without giving a notice to the petitioner, how you can directly appoint an officer, inquiry officer. So that order was passed telling that issue notice to the petitioner with regard to that charge, take the explanation, then if you are not satisfied, then appoint the inquiry officer. That was the issue.
Yes. What is that which is challenged in the petition?
It's factually incorrect. Kindly turn to page 33, annex D. First charge. Verbatim, the very same word is used. Page 35 is the articles of charge.
Yes.
But what is the charge is to be looked into from articles of charge, not the inquiry officer's report.
Yes.
Page 35. Charge number 1.
Yes.
You, B.R. Chaluraju.
No, then if same charges,
Same charge.
can they not conduct an inquiry? Just because earlier.
They can hold further inquiry. But rule 11A of the CC rules.
Further inquiry means by appointing that another inquiry officer.
Your Lordship may kindly compare, but before appreciating the rules,
yes.
Kindly Lord see page 35 and Lord the articles of charge, which is fresh articles of charge at the page 81, 35 and 81. Verbatim, Lord, the very same word is used.
Yes.
Statement of imputation of misconduct. B.R. Chaluraju reported for duty from job. It is noticed that in column number 17 of the application.
Yes, same as me.
Verbatim same. There are two.
Wait, let him. Yes.
Let him argue.
Yes.
Verbatim, Lord, same.
Yes.
If you Lordship compares page 35 and 81.
Yes.
It is Lord one and the same.
Yes.
But pursuant to this,
yes.
Lord, the 7/3/2018, page 89. Lord, another inquiry officer is appointed. Another inquiry officer is appointed.
Yes.
But I appeared.
Yes.
Thereafter, Lord, I find written statement of defense, page 98, annex P.
Yes.
In the Lord inquiry, Lord,
I think I am also part of that one. This thing in this. Nobody has noticed that. That contempt is. I am also thing in contempt. Yes.
Page 91.
Yes, and it's not proper.
And reinstatement there. My Lord said you are at liberty to challenge the endorsement.
No, that is also a point for consideration now. That whether.
Yes.
Yes. Yes.
You heard MNA. Please heard the vision being sorted towards.
Yes. Yes. Anyhow, that yes. Not before me. Yes. No, by this thing now, I have seen that. Otherwise, I would have completed the argument. No, you have not noticed that. I have not seen that. I'm also. No, see again. That finding also can be considered whether this court has given a liberty or not. I don't think it's anyhow. Take that. You want registry is directed to take necessary order from Honorable Chief Justice and post this matter next week.